Are you filing a pleading in relation to a case before the Supreme Court? The eCourt PH portal is your new digital gateway to the entire Philippine judiciary. With eCourt PH, lawyers can file all cases before the Supreme Court, except administrative and bar matters, upload pleadings, and track their progress all online, anytime, anywhere. In this video, we'll guide you through how to use the platform and get your filings done quickly, securely, and in full compliance with the rules of court. Let's get started. Go to and access the Philippine Judiciary platform through the website portal.judiciary.gov.ph. Simply log in with your credentials. Non-PJ365 users should create an account and undergo the required verification process through the platform. Once you have a verified account, you just need to sign in and select eCourt PH. Please note that some PJ365 users must complete the verification process in the Philippine Judiciary platform and wait for confirmation before you can access eCourt PH. Start by clicking eCourt PH. Welcome to your dashboard. Here, you'll find the menu bar, cases filed per jurisdiction, statistics panels, list of filed cases and drafts, and your general profile information. These are everything you need at a glance. Ready to file? Click the New Filing button to begin. Next, select the Supreme Court as the jurisdiction for your filing. Here, you have the option whether you're filing a new case or submitting a pleading in relation to an existing one. Part 1. Filing a new case. Case details. To start filing a new case, the first thing that you need to do is to fill in key information about your case. Enter the case category, case type, and the number of cases being elevated to the Supreme Court. When you're ready, click Next to move forward, or hit Back to Dashboard if you want to return to the main page. Now, let's indicate the court of origin. Choose whether this is an original filing to the Supreme Court or an appeal from a lower court or quasi-judicial agency. If it's an appeal, click Add Details if filing an appeal from lower court or quasi-judicial agency, and fill in the necessary fields such as the name of the court or agency, case number in the court of origin, and other important information. You may add as many entries as necessary to indicate the procedural history of the case, leading to its elevation to the Supreme Court. When you're all set, click Next to continue. For the lawyer's details, click the Update Details of your law firm or government agency or as a solo practitioner to add the names and details of the counsel handling the case. A pop-up window will appear. If you are filing on behalf of a government entity or a law firm, select the appropriate agency or firm from the drop-down list and provide the required details. Once all information has been entered, click Update Lawyer Details to save. Otherwise, simply click Cancel to close the pop-up window. If you have co-counsels, you may add them so they can view the files by clicking Add Details of other lawyer handling the case at the lower left portion of your screen. A pop-up window will appear where you'll need to verify each lawyer's details by entering their roll number, first name, and last name. You may add more lawyers who are co-handling the case with you. Once all details have been reviewed and confirmed, click Next to proceed. In the Parties Details section, you will be required to identify all petitioners and respondents to the case. To begin, click Add Petitioner or Add Respondent. A pop-up window will appear. Provide the necessary information for each party, including their classification, mailing address, and whether they are represented by an authorized representative. If a party is represented by counsel, you may select the appropriate lawyer from the drop-down list. This list is automatically populated based on the information you previously entered under lawyer's details. You may add multiple petitioners or respondents as may be applicable to the case. Upon completing the party's details section, you may now proceed to upload the necessary documents in support of your filing. Separate upload fields are provided for the initiatory pleading and the list of other documents or annexes. Please ensure that each file does not exceed 100 megabytes in size. Please note that pursuant to the guidelines on the transition to electronic filing in the Supreme Court, approved last May 20, 2025, initiatory petitions or pleadings and motions for extensions of time to file those petitions or pleadings in the following instances shall also be filed electronically with the Supreme Court through the Philippine Judiciary Platform from July 1, 2025 until September 30, 2025. Please note, however, that filing through the Philippine Judiciary Platform is only an additional requirement until September 30, as the primary mode of filing remains as provided under the rules of court. Beginning October 1, 2025, the electronic filing and service through the Philippine Judiciary Platform shall be mandatory for filers. Initiatory petitions or pleadings shall be filed through the Philippine Judiciary Platform, but their service shall be in accordance with the rules of court. Once the documents are uploaded, you may now proceed to pay the relevant fees for filing. Here, you may update relevant information, including fee exemptions or your payment details. After completing your payment, carefully review all case information provided in the previous steps. Just a reminder, if you need more time at any point in the process, your work is automatically saved in the drafts located at the bottom of your dashboard. You can return to it anytime when you're ready to continue, just before you submit it. Once verified, you may proceed to file the case by clicking the Submit and File button. Upon successful submission, the case will appear on your dashboard. You may continue to monitor its progress and view case details by selecting it from the list. Part 2. Filing a pleading in relation to an existing case. Now that we've walked through the process of filing a new case, let's move on to how you can file in relation to an existing case before the Supreme Court. This applies when the matter you're filing is connected to a previously filed case. The steps are similar, but with a few key differences tailored to the context of an existing case. On your dashboard, click New Filing to initiate the process. Select the appropriate jurisdiction and then choose Related to Existing Case. Enter the existing case number in the designated field and indicate your role in the case. If this is your first time filing in the case, an entry of appearance will be generated after the filing. Click Enter Appearance. You will then select the party you are representing. In instances where a party does not have contact details recorded, you may input a valid email address and phone number. Ensure that the correct party is selected before clicking Save to confirm your appearance and contact information. That wraps up our instructional guide on how to file cases using eCourt PH, whether you're filing a new case or submitting pleadings for an existing one. Right now, this system is available for filings before the Supreme Court, but its adoption across other courts is expected to follow soon, with the Supreme Court pushing forward with its modernization efforts. eCourt PH is a big step toward making court processes faster, more transparent, and easier for everyone to access.
The Philippine Judiciary Platform is the digital gateway to the Philippine judiciary. Here, you can access the Barista app for applicants to the bar, the JBC Oras for applicants to the judiciary, and eCourt PH for electronic filing to the Supreme Court. How to create an account through the Philippine Judiciary Platform. Click Create an Account. Choose whether or not you are an employee of the Philippine Judiciary. You will be asked to tick whether or not you are a member of the Philippine Bar. If you are a member of the bar, remember to input your name as registered in the Philippine Bar membership. If you are a recently married female, you may still have to use your maiden name, if that is what is registered in your bar membership. Upload your recent ID photos and government IDs. You should likewise be asked to upload your company ID or an additional government ID. Wait for the verification after clicking the Request Account before you may be able to create a password and answer a security question. Go to your email and follow the succeeding instructions. Click Verify My Account Request. Once verified, you will receive another email welcoming you to the Philippine Judiciary Platform. Click Get Started. Follow the instructions on how to activate your account by choosing a security question and typing your answer. Next, nominate your password. This is the password you will use whenever you are using the platform. If you are not a member of the Philippine Bar, uploading of IDs is not required. You may proceed to create your password and security question. Congratulations! You now have an account in the Philippine Judiciary Platform. May hearing ka. Alam mo paano pumunta sa trial court. Kailangan mo ng court clearance. Alam mo contact number ng korte. Papiyansahan mo anak mo. Alam mo saan ang korte.
Hindi nga eh.
Gusto niyo ba ng civil wedding sa court? May kilala ba kayong judge? May cellphone o laptop ba kayo? Sa website ng Supreme Court, madaling makakahanap ng impormasyon para makatawag o makapunta sa trial courts. I-click ang court locator. Makikita dito ang branch, court type, pangalan ng judge, region o city. Kahit isa lang dito ang meron ka, makikita mo na agad ang court na kailangan mo.
High-tech.
Pindutin ang phone number at makakatawag ka na.
Madali na.
Konektado din ang website sa mobile map para matulungan ka sa direksyon papunta, lakad, drive o commute.
You have reached your destination.
Accessible.
Ang court locator ng SE website ay ginawa para makatulong makamit ng bawat Pilipino ang mabilis at patas na hustisya. The Philippine Reports is an authorized publication of Supreme Court decisions. Published in book form, it now spans hundreds of volumes. It is an essential resource for lawyers, judges, legal researchers, law schools, and students. However, accessing the Philippine reports can be challenging because of its cost and inaccessibility to those who are in remote areas. Thus, the Supreme Court saw the need for the Philippine reports to be more accessible to the legal community and the general public. Introducing Philippine Reports Ebooks. Copies can now be accessed by anyone, anytime, anywhere for free. Philippine Reports at your fingertips. The reports can now be accessed in formats that are useful in various applications. The PDF format can be read from any device. The EPUB can be read in any ebook reader. Finally, the flipbook allows users to read the entire volume like an actual book. It also allows the user to easily search keywords within the entire text. In line with the target outcomes of the Strategic Plan for Judicial Innovations of Efficiency, Innovation, and Access, the new Philippine Reports Ebooks will give the legal community much-needed tools to help the public to an accessible, innovative, and efficient judiciary.
Presenting the Supreme Court Style Book, a groundbreaking resource designed to elevate the standard of judicial writing. Decision writing is a critical stage in the administration of justice. The Style Book sets the tone for what is expected of court decisions: graceful, powerful, yet accessible. It guides us toward clarity, consistency, and uniformity, enabling the public to clearly understand court decisions. Lawyers and other stakeholders are called upon to dive into the Style Book to study, learn, and adhere to its instructions, a compilation of wisdom from the best authorities and references in the field. The Supreme Court Style Book, where eloquence meets justice. Embrace the future of judicial writing.
The Supreme Court podcast is now available on Spotify. Listen to discussions and summaries of significant Supreme Court decisions and other issuances, as well as latest Supreme Court projects.
Have you ever had relatives asking you what's the quickest way to secure an
Is a
annulment?
company policy setting a lower retirement age for women discriminatory?
Can a bank be found negligent for allowing unauthorized
Can you go to
withdrawals?
jail for marital infidelity?
Very honored to have with us Court Administrator Raul B. Villanueva.
Every year, our caseload inventory is decreasing.
Catch the latest episodes on the Supreme Court website and its official accounts on YouTube, Facebook, X, Instagram, and now also on Spotify. New episodes out each week. From the Supreme Court of the Philippines, here's the latest.
Decisions that matter.
The Supreme Court
In
has
another
ruled.
decision,
The SC has acquitted 2 individuals.
Events that shape the law.
The SC welcomed the signing into
The
law. Ceremony sealed the partnership.
The Supreme Court Public Information Office brings you the week's key updates. Catch SCPH updates every Friday on the court's official social media channels.
On June 28, 2022, the Supreme Court en banc, led by Chief Justice Alexander G. Gismundo, approved the Strategic Plan for Judicial Innovations 2022 to 2027, or the SPJI. The SPJI aims to achieve three major outcomes: efficiency, innovation, and access. Under efficiency, the court will undertake to streamline court systems and processes. Some of the proposed activities to achieve efficiency are the judiciary-wide organizational review and restructuring, a system-wide process mapping, a public service continuity plan, the use of an experience-based and data-driven performance metrics and evaluation system, a campaign for ethical responsibility, the organizational review and process mapping of the Judicial Integrity Board, the establishment of mental health units, the institutionalization of a socialized health insurance plan, free or subsidized mandatory physical and mental health examinations for court employees. Under innovation, the judiciary will modernize court processes and operations through technology adaptive management. Some of the proposed activities to achieve innovation are capitalizing on artificial intelligence for legal research and other court operations, developing and deploying the upgraded e-court system, formulating the Judiciary Enterprise ICT Governance Framework, developing a 5-year ICT strategic plan and a Judiciary MIS Operations Manual, developing the network infrastructure for the judiciary, the establishment of a Philippine Judiciary online learning platform which will be administered by the Philippine Judicial Academy, the revision of the rules of court. Under access, the SPJI aims to enhance public access to information and legal services. Some of the proposed activities to achieve access are the development of intelligent platforms for self-help legal services, the continued institutionalization of the Clinical Legal Education Program in law school, the strengthening of the IBP Legal Aid Program, the conduct of gender sensitivity and inclusivity reorientation and application workshops considering new laws and issuances like the court's own recent issuance, the guidelines for the use of gender-fair language in the judiciary and gender-fair courtroom etiquette, the issuance of guidelines for victim-sensitive courts, an institutional review and assessment of the Sharia justice system, a review of the Sharia rules of court. While the road ahead may be filled with challenges, we have faith that with all of us working together, the justices, judges, court officials and employees, law practitioners, court users, the academe, the media, and the general public, we can truly achieve this goal of timely justice for all. Efficiency, innovation, access. 3 targeted outcomes towards the ultimate goal of the timely delivery of justice.
Are you filing a pleading in relation to a case before the Supreme Court? The eCourt PH portal is your new digital gateway to the entire Philippine judiciary. With eCourt PH, lawyers can file all cases before the Supreme Court, except administrative and bar matters, upload pleadings, and track their progress all online, anytime, anywhere. In this video, we'll guide you through how to use the platform and get your filings done quickly, securely, and in full compliance with the rules of court. Let's get started. Go to and access the Philippine Judiciary platform through the website portal.judiciary.gov.ph. Simply log in with your credentials. Non-PJ365 users should create an account and undergo the required verification process through the platform. Once you have a verified account, you just need to sign in and select eCourt PH. Please note that some PJ365 users must complete the verification process in the Philippine Judiciary platform and wait for confirmation before you can access eCourt PH. Start by clicking eCourt PH. Welcome to your dashboard. Here, you'll find the menu bar, cases filed per jurisdiction, statistics panels, list of filed cases and drafts, and your general profile information. These are everything you need at a glance. Ready to file? Click the New Filing button to begin. Next, select the Supreme Court as the jurisdiction for your filing. Here, you have the option whether you're filing a new case or submitting a pleading in relation to an existing one. Part 1. Filing a new case. Case details. To start filing a new case, the first thing that you need to do is to fill in key information about your case. Enter the case category, case type, and the number of cases being elevated to the Supreme Court. When you're ready, click Next to move forward, or hit Back to Dashboard if you want to return to the main page. Now, let's indicate the court of origin. Choose whether this is an original filing to the Supreme Court or an appeal from a lower court or quasi-judicial agency. If it's an appeal, click Add Details if filing an appeal from lower court or quasi-judicial agency, and fill in the necessary fields such as the name of the court or agency, case number in the court of origin, and other important information. You may add as many entries as necessary to indicate the procedural history of the case, leading to its elevation to the Supreme Court. When you're all set, click Next to continue. For the lawyer's details, click the Update Details of your law firm or government agency or as a solo practitioner to add the names and details of the counsel handling the case. A pop-up window will appear. If you are filing on behalf of a government entity or a law firm, select the appropriate agency or firm from the drop-down list and provide the required details. Once all information has been entered, click Update Lawyer Details to save. Otherwise, simply click Cancel to close the pop-up window. If you have co-counsels, you may add them so they can view the files by clicking Add Details of other lawyer handling the case at the lower left portion of your screen. A pop-up window will appear where you'll need to verify each lawyer's details by entering their roll number, first name, and last name. You may add more lawyers who are co-handling the case with you. Once all details have been reviewed and confirmed, click Next to proceed. In the Parties Details section, you will be required to identify all petitioners and respondents to the case. To begin, click Add Petitioner or Add Respondent. A pop-up window will appear. Provide the necessary information for each party, including their classification, mailing address, and whether they are represented by an authorized representative. If a party is represented by counsel, you may select the appropriate lawyer from the drop-down list. This list is automatically populated based on the information you previously entered under Lawyer's Details. You may add multiple petitioners or respondents as may be applicable to the case. Upon completing the party's details section, you may now proceed to upload the necessary documents in support of your filing. Separate upload fields are provided for the initiatory pleading and the list of other documents or annexes. Please ensure that each file does not exceed 100 megabytes in size. Please note that pursuant to the guidelines on the transition to electronic filing in the Supreme Court, approved last May 20, 2025, initiatory petitions or pleadings and motions for extensions of time to file those petitions or pleadings in the following instances shall also be filed electronically with the Supreme Court through the Philippine Judiciary Platform from July 1, 2025 until September 30, 2025. Please note, however, that filing through the Philippine Judiciary Platform is only an additional requirement until September 30, as the primary mode of filing remains as provided under the rules of court. Beginning October 1, 2025, the electronic filing and service through the Philippine Judiciary Platform shall be mandatory for filers. Initiatory petitions or pleadings shall be filed through the Philippine Judiciary Platform, but their service shall be in accordance with the rules of court. Once the documents are uploaded, you may now proceed to pay the relevant fees for filing. Here, you may update relevant information, including fee exemptions or your payment details. After completing your payment, carefully review all case information provided in the previous steps. Just a reminder, if you need more time at any point in the process, your work is automatically saved in the drafts located at the bottom of your dashboard. You can return to it anytime when you're ready to continue, just before you submit it. Once verified, you may proceed to file the case by clicking the Submit and File button. Upon successful submission, the case will appear on your dashboard. You may continue to monitor its progress and view case details by selecting it from the list. Part 2. Filing a pleading in relation to an existing case. Now that we've walked through the process of filing a new case, let's move on to how you can file in relation to an existing case before the Supreme Court. This applies when the matter you're filing is connected to a previously filed case. The steps are similar, but with a few key differences tailored to the context of an existing case. On your dashboard, click New Filing to initiate the process. Select the appropriate jurisdiction and then choose Related to Existing Case. Enter the existing case number in the designated field and indicate your role in the case. If this is your first time filing in the case, an entry of appearance will be generated after the filing. Click Enter Appearance. You will then select the party you are representing. In instances where a party does not have contact details recorded, you may input a valid email address and phone number. Ensure that the correct party is selected before clicking Save to confirm your appearance and contact information. That wraps up our instructional guide on how to file cases using eCourt PH, whether you're filing a new case or submitting pleadings for an existing one. Right now, this system is available for filings before the Supreme Court, but its adoption across other courts is expected to follow soon. With the Supreme Court pushing forward with its modernization efforts, eCourt PH is a big step toward making court processes faster, more transparent, and easier for everyone to access.
The Philippine Judiciary Platform is the digital gateway to the Philippine judiciary. Here, you can access the Barista app for applicants to the bar, the JBC Oras for applicants to the judiciary, and eCourt PH for electronic filing to the Supreme Court.
How to create an account through the Philippine Judiciary Platform. Click Create an Account. Choose whether or not you are an employee of the Philippine Judiciary. You will be asked to tick whether or not you are a member of the Philippine Bar. If you are a member of the bar, remember to input your name as registered in the Philippine Bar membership. If you are a recently married female, you may still have to use your maiden name, if that is what is registered in your bar membership. Upload your recent ID photos and government IDs. You should likewise be asked to upload your company ID or an additional government ID. Wait for the verification after clicking the Request Account before you may be able to create a password and answer a security question. Go to your email and follow the succeeding instructions. Click Verify My Account Request. Once verified, you will receive another email welcoming you to the Philippine Judiciary platform. Click Get Started. Follow the instructions on how to activate your account by choosing a security question and type in your answer. Next, nominate your password. This is the password you will use whenever you are using the platform. If you are not a member of the Philippine Bar, uploading of IDs is not required. You may proceed to create your password and security question. Congratulations! You now have an account in the Philippine Judiciary platform.
All please rise. The Honorable, the Chief Justice of the Republic of the Philippines, the Senior Associate Justice, and the Associate Justices of the Supreme Court of the Philippines. Hear ye, hear ye, hear ye. All persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the court is now in session.
Please be seated.
Madam Clerk of Court, please call the case before us.
Good afternoon, Your Honors. Scheduled for this afternoon's oral arguments is GR number 257575, Melvin A. Baluyot, petitioner, versus Maria Fe C. Antonio Baluyot and Republic of the Philippines, respondents. Thank you, Your Honor.
Okay. Counsels, please enter your appearances, please. Starting with the petitioners, then the respondent.
Good afternoon, Your Honor. I'm Attorney Melvin De Castro Mane, appearing as counsel for the petitioner, Your Honor.
Good afternoon, Your Honors. The Office of the Solicitor General respectfully enters its appearance for Respondent, Republic of the Philippines. I'm Solicitor General Darlene Marie B. Berberabe. With me this afternoon, Your Honors, our Assistant Solicitor General Marisa B. De La Cruz Galandines, Assistant Solicitor General Mirna N. Agno Canuto, and State Solicitor Joseph Roman D. De La Cuesta. Other lawyers of the OSG are in the gallery to provide assistance whenever necessary. Thank you.
For the amici curiae, Justice Adolfo S. Ascuna, retired.
Respectfully appearing as amicus curiae, Your Honor, Adolfo S. Ascuna. Thank you.
Attorney Elizabeth Agiling Pangalanan.
Sorry. Good afternoon, Your Honors. Respectfully appearing as amicus curiae, Professor Elizabeth Agiling Pangalangan, Your Honors.
Thank you. Attorney Milencio S. Santa Maria Jr.
Good afternoon, Your Honors. I'm Attorney Melencio Santa Maria, respectfully appearing as one of the amici curiae.
Attorney Maria Liza Lopez Rosario.
Good afternoon, Your Honors. Attorney Maria Liza Lopez Rosario as amicus curiae.
Thank you. Attorney Maria Carolina T. Ligarda.
Good afternoon, Your Honors. Attorney Ligarda as amicus curiae.
Thank you. Attorney Eliezer Ambatali.
Good afternoon, Your Honors. I'm Attorney Eliezer Paraiso Ambatali, representing Dr. Claire Dennis S. Mapa, Undersecretary of the Philippine Statistics Authority as amicus curiae.
Thank you. Is Petitioner Melvin Baluyot around, Mr. Counsel?
No, Your Honor, he was not able to make it. He's still in the United States as of now, Your Honor.
What about the respondent? Are you aware if Maria Pe, si Antonio Baluyot around the court?
For the record, Your Honor, respondent or private respondent actually didn't make her appearance in actually even the trial court, Your Honor.
Thank you for the information. Okay. As discussed during the preliminary conference held on July 1, 2025, counsel for the petitioner and counsel for the respondents shall each be allotted 15 minutes to deliver respective opening statements. For each amicus curiae shall be given 10 minutes to present their submissions before the court. The counsel for the petitioner now may approach the podium for your presentation.
Thank you, Your Honor. May it please the Honorable Court, good afternoon, everyone. I'm Attorney Melvin De Castro Mane, respectfully acting as counsel for the petitioner. I rise before this Honorable Court to assert the petitioner's argument in this petition for review, filed pursuant to Rule 45 of the Rules of Court. The core issue in this petition is whether a petitioner who was a Filipino citizen at the time who obtained a divorce from his Filipino spouse in the United States, subsequently acquired American citizenship, and later reacquired Philippine citizenship before filing a petition for recognition, may validly invoke the second paragraph of Article 26 of the Family Code to seek judicial recognition of foreign divorce decree. The petitioner is a natural-born Filipino citizen, entered a marriage in the Philippines, and during the subsistence of this marriage, he obtained a divorce decree in the United States. A crucial aspect of this case is that at the precise moment of this foreign divorce was obtained, the petitioner remained a Philippine national. After the finalization of the divorce, the petitioner acquired American citizenship through naturalization. Later, the petitioner reacquired Philippine citizenship pursuant to Republic Act No. 9225. Now, the petitioner seeks recognition of this foreign divorce before our local court, aiming to clarify his marital status under the Philippine law. It is undeniable that this case presents a matter of first impression. It does not fall squarely within the factual matrix of prior rulings rendered by the Honorable Court. In Obrecido, the divorce was secured by the foreign spouse. In Manalo, the divorce was obtained by a former Filipino who already acquired foreign citizenship at the time of the dissolution. By contrast, this case, the petitioner obtained the divorce while still a Filipino citizen, acquired American citizenship thereafter, and eventually returned to the fold of the Philippine nationality. This sequence of events introduces a nuanced and more complex scenario that requires a thoughtful and purposive application of the law. The second paragraph of Article 26, paragraph 2 of the Family Code was intended to protect a Filipino spouse left bound by Philippine law after a divorce initiated by a foreign divorce in a mixed marriage. Some argue that it does not apply when the marriage began between two Filipinos or when the Filipino spouse obtained the divorce. However, recent jurisprudence has moved toward a broader, more equitable interpretation that better reflects the evolving realities of cross-border marriages. While Article 26, paragraph 2 of the Family Code may not strictly apply in this case, due to the nationality principle under Article 15 of the Civil Code, the ruling in Republic in Manalo, which emphasized the need for foreign citizenship at the time of divorce, and the restorative effect of RA number 225. The petitioner respectfully submit that recognition of foreign divorce remains legally viable for the following circumstances or reasons. The Honorable Court may opt again to adopt a liberal and purposive interpretation of Article 26, paragraph 2 of the Family Code. Article 26, paragraph 2 of the Family Code was enacted to address the inequities paid by Filipinos living abroad who, upon returning to the Philippines, are still considered married under Philippine law despite having obtained a valid divorce under foreign law. A liberal and purposive interpretation of this law empowers the Honorable Court to extend recognition in the present case, considering that the petitioner subsequently acquired American citizenship, under which the divorce he obtained while still a Filipino is deemed valid and effective. In Manalo, the Honorable Court allowed the recognition of foreign divorce obtained by a former Filipino who subsequently reacquired Philippine citizenship. The Court emphasized the intent of Article 26, paragraph 2, which is to protect the Filipinos from being perpetually bound to a marriage that has already been dissolved under foreign law. Applying the same reasoning, the court may similarly hold that if the petitioner was still a Filipino citizen at the time the divorce was obtained, but later became a foreign national and thereafter reacquired Philippine citizenship, the divorce may still be recognized, provided that it was valid under the petitioner personal law at the time the recognition is sought. While citizenship at the time of divorce is a relevant factor, in cases involving a change in citizenship after divorce, such in Manalo, where the petitioner became a foreign citizen after divorce but before seeking recognition, it is not, with due respect, not the controlling criterion for purposes of a recognition of foreign divorce in this case. With due respect, the proper criterion should be the legal status of the party at the time recognition is sought. This is because recognition of foreign divorce is prospective in nature and affects a person's civil status moving forward. Accordingly, it is the petitioner's status at the time the request for recognition is made that should govern, and not the status at the time the divorce was obtained. For it is at the moment of recognition that Philippine courts determine whether the foreign law should have effect within the country. For this reason, it is not logical to make the petitioner legal status at the time of divorce determinative, especially so when the individual was already a foreign national at that point, when his personal law has changed, and the divorce he obtained may be valid under that new law. Consequently, although the petitioner was still a Filipino citizen when he secured a foreign divorce, his subsequent acquisition of foreign nationality altered his personal law. At that point, the foreign divorce he had obtained as a Filipino began to operate in defining his civil status under his new personal law. Conversely, if the recognition were to depend solely on petitioner's citizenship at the time the divorce was obtained, it would lead to absurd and inequitable result, as the petitioner will be deemed bound by marriage that has already been validly dissolved under the foreign law, notwithstanding his subsequent acquisition of foreign nationality. In effect, it would disregard the legal significance of his subsequent change in citizenship, which shifted his personal law to that of foreign jurisdiction, where the divorce is recognized as valid and effective. As a result, a rigid chronological approach, which is adopted in the case of Manalo and Abrasido, where it undermines the intent of Article 26, Paragraph 2 of the Family Code, should be avoided, and legal interpretation must account for the realities of transnational lives of Filipinos, including those who hold dual citizenship or are married to foreign nationals. Finally, to deny recognition on the sole basis of petitioner's citizenship at the time of divorce elevates form over substance and undermines the principle of equal protections of laws and flexibility of legal system that responds to contemporary global realities. Extending jurisdiction in this case does not, with due respect, violate the nationality principle under Article 15 of the Civil Code. On the contrary, extending jurisdiction in this case affirms the nationality principle, given that during the period in which the petitioner was a foreign national, it was the law of his country of citizenship that governed his civil status. To insist that the Philippine law continued to govern the petitioner during the period reflects a misapplication of Article 15 and undermines the very nationality principle it seeks to uphold. In this case, divorce happened when petitioner was a Filipino, so the Philippine law applies, and strictly speaking, the divorce is void. However, when the petitioner later became a foreign national, his personal law changed to that of foreign nationality and ceased to be governed by the Philippine laws. This means that divorce he obtained while still a Filipino became valid and effective under his new personal law after his citizenship change. Hence, while petitioner may have lacked the capacity to obtain a valid divorce under the Philippine law at the time it was granted, his subsequent change in citizenship and personal law provides him a legal basis upon which the divorce obtained as a Filipino became valid and effective. Petitioner's dual citizenship does not adversely affect his standing to file this petition. With due respect, RA number 225 supports a recognition of foreign divorce in this case. Reacquiring Philippine citizenship under RA 9225 does not cancel or undo valid legal acts, such as foreign divorce undertaken when the individual was a foreign national. The law recognizes the continuity of rights and legal effects performed under foreign law regime during the period of the foreign citizenship remain valid and effective. RA number 225 was not enacted to erase legal events that occurred under a different portion of law, but rather to restore rights and reintegrate natural-born Filipino into full legal framework of Filipino citizenship, and this include the restoration of both the political and civil rights without discrimination or diminished right. Furthermore, there is nothing in the text of the law or intent of the law that requires a reacquiring citizenship to repudiate valid acts such as foreign divorce entered under the laws of another country during the time they were governed by a different personal law. To disregard such act will be both unfair and inconsistent with the remedial purpose of the statute. Although RA number 9225 contains a provision stating that reacquiring individuals are deemed not to have lost their Filipino citizenship, this provision, with due respect, must be interpreted as prospective in nature. It restores rights such as the right to own land and the right to vote, but it does not invalidate legal events that occurred under the foreign law or during the intervening period when the individual was governed by the personal law of a foreign sovereign. Under international law, a person's civil status is governed by one's nationality. In the context of this case, although the foreign divorce was obtained while petitioner was still a Filipino, it later became valid under the law of his new nationality when he acquired foreign nationality. This legal change should be respected and not negated simply because the petitioner subsequently reacquired Philippine citizenship under RA 9225. Hence, the foreign divorce he obtained should remain valid and should be recognized with due respect by the Philippine court. The full restoration of a returning Filipino's civil and political rights necessarily entails recognition of legal acts that were valid at the time they were undertaken. The interpretation more accurately reflects the legislative intent of RA number 9225, which is merely to restore citizenship in a technical sense, but to facilitate the meaningful and equitable reintegration of the individual into the Philippine legal order. To construe RA number 225 in a manner that disregards and invalidates the legal effects of a foreign divorce would unjustly penalize natural-born citizens for exercising the right to reacquire Philippine citizenship. It would likewise erroneously imply that the reacquisition nullifies not only their prior foreign nationality, but all the legal developments and changes in civil status lawfully effected under a foreign legal regime. With due respect, such approach would undermine legal certainty for dual citizens and cast serious doubt on the validity of the essential civil status events, including marriages and divorces, thereby jeopardizing the stability and coherence of their legal identity under the Philippine law. Another ground upon which this petition is based is that to deny recognition may constitute a violation of petitioners' right of equal protections of law. The Equal Protection Law under Section 1, Article 3 of 1987 Constitution mandates that all persons similarly situated are treated alike under the law. While the state may create classification that must satisfy the test of reasonableness, they may be based on substantial distinction, germane to the purpose of the law, not confined to present conditions, and apply equally to all within the class. In the case of law, there exists no substantial distinction between former Filipino citizens who obtained a foreign divorce before acquiring foreign citizenship and those who did so after naturalization as foreign national that would warrant different treatment under the Philippine law. Both former Filipinos, upon acquiring foreign nationality, are deemed aliens for purposes of Article 26, Paragraph 2 of the Family Code and governed by the respective foreign personal laws, pursuant again to Article 15 of the Civil Code. The Act of Naturalization severs the individual's juridical tie to Philippine personal law, including those governing marital relations. Accordingly, to permit the recognition of foreign divorce only which is obtained after the change of citizenship, while withholding such recognition when the divorce was secured prior to naturalization, creates a classification that is not based on real and substantial distinction. Such classification, with due respect, is constitutionally infirm because it would violate the Equal Protection Clause. It relies on timing of citizenship acquisition, which has no rational connection to the legislative purpose of Article 26, Paragraph 2 of the Family Code. The Honorable Court in Obrecido did not make recognition of foreign divorce contingent on who initiated the divorce or the timing of change in citizenship. It required only that one of the spouses had acquired foreign nationality. Similarly, in Manalo, the court affirmed that even divorce initiated by Filipino spouse may be recognized, provided that the marriage is no longer valid under the foreign spouse national law. Consequently, imposing conditions that are not expressly found in the text of Article 26, Paragraph 2 of the Family Code offends the Equal Protection Clause of the Constitution. The operative must be the existence of a mixed marriage at the time the recognition is sought, for it is that moment that the court extended recognition that Philippine courts determine whether the foreign divorce shall have legal effect within the country. Another grounds upon which this petition is anchored is the doctrine of unclean hands does not apply in this case. The doctrine of unclean hands, as we know, is an equitable principle requiring that he who comes in equity must comes with clean hands. Applying this doctrine to this petition for recognition under article is incorrect. Petition for recognition article is not an equitable action, but a special proceedings covered by private international law and procedural due process. It seeks to recognize a valid juridical act performed abroad and does not involve discretionary relief. As held in Manalo, the only relevant question are whether the foreign divorce decree is authentic, final, and obtained in accordance with applicable foreign law. Moral force or the petitioner conduct is irrelevant. Article 26, Paragraph 2 does not distinguish between innocent at fault spouses, and it settled that the law must not read into the law distinction that the legislature did not make. The recognition of foreign divorce is a question of legal validity and not of moral culpability. Next is whether the court should inform the Congress of the present controversy. The involving jurisprudence and the recognition of foreign divorce in the Philippines, particularly through Obrecido and Manalo, has significantly expanded the scope of Article 26, Paragraph 2. However, repeated adjudication has already revealed a statutory gap that result in unequivocal protection, procedural burdens, and conceptual ambiguity. In this context, a vital question arises: should this honorable court formally call the attention of Congress to this deficiency and recommend legislative reform? Although the honorable court has liberally and purposely construed Article 26, Paragraph 2, it remains bound by the statute textual limitation. The law does not expressly cover divorces initiated by Filipino spouses, nor does it address dual citizenship. This omission, with due respect, may lead to interpretive uncertainties, particularly in relation to RA number 9225. As a result, the burden of achieving just outcomes has fallen into judicial interpretation rather than the legislative clarity. It is established in jurisprudence.
Sorry, time's up.
Okay, sorry. That to be, Your Honor.
Thank you. May we request the Solicitor General to proceed with her presentation?
Thank you, Your Honor. Paragraph 2 of Article 26 of the Family Code has sparked much legal discussion since the code came into effect in 1988. This second paragraph has been the subject of many cases, and as a result, our jurisprudence has developed to clarify its application. Today, we find ourselves once again facing questions about how this law should be understood and applied. At the heart of this case lies a tension between, on one hand, our long-standing state policy disallowing absolute divorce between Filipino citizens and our consistent adherence to the nationality principle, and on the other, an unjustified invocation of dual nationality to render inapplicable this state policy. Your Honors, concededly, Article 26 recognizes certain types of foreign divorce, but only as an exception. And the exception is very clear. It applies only when the marriage is between a Filipino and a foreigner. The issue before the court today is whether this narrow exception applies to the petitioner's case. We respectfully submit that it does not. We begin with two facts that are not in dispute. First, when the petitioner divorced his wife in the United States on 18 October 2010, both he and his wife were still Filipino citizens. Second, although he acquired American citizenship on 20 February 2019, 8 years after obtaining divorce, and while he reacquired Filipino citizenship a little over a year after that, on 3 July 2020, he and his wife were nevertheless still Filipinos at the time when the divorce was granted. On that basis alone, Your Honors, the petition should be denied. Our Constitution states that marriage is the foundation of the family and mandates the state to protect and strengthen this institution. The Family Code echoes this, declaring marriage a special contract of permanent union, one whose consequences and effects can never be subject to any personal preferences or private agreements. And this honorable court has consistently ruled that Philippine law does not allow absolute divorce between Filipino citizens. This has been settled law since 1965 when, in Chavez versus Escaño, this honorable court emphasized that recognizing a foreign divorce between two Filipino citizens would be a clear violation of Philippine public policy. Why is this so? Because of the nationality principle enshrined in Article 15 of the Civil Code. The principle subjects all Filipino citizens to Philippine laws on, among others, personal and family relations even when they are living or married abroad. And that includes the policy that disallows absolute divorce. True, paragraph 2 of Article 26 creates a narrow exception to this policy. It allows a Filipino spouse to remarry if their foreign spouse validly obtained a divorce abroad, and that divorce allows the foreign spouse to remarry. And while this court has further clarified its interpretation of this provision by later holding irrelevant who between the foreign or Filipino spouse initiated the divorce, it has nonetheless preserved one key condition for the application of this narrow exception, that the marriage must be mixed, meaning one party is a Filipino and the other a foreigner at the time of divorce. This exception is rooted in the rule of reason and the legislative intent to avoid the absurd situation where a Filipino will remain legally bound to a foreign spouse who, under foreign law, has already been released from their matrimonial bond. As the Code Commission records show, the framers of this law, following the court's reasoning in Van Dorn, initially justified the inclusion of this exception to prevent such anomalies. The records likewise show that they later wavered in their initial decision, preferring instead to await legislative action on the most complex issue of divorce. Article 26, paragraph 2 exists today because then President Corazon Aquino approved its inclusion in our family code with one critical caveat, that it should not apply to Filipino couples who simply obtain a foreign divorce abroad. To hold otherwise is to unduly discriminate between Filipinos who can afford to fly to distant shores to sever their marital bonds and the vast majority of our brethren without resources to do so. Your Honors, in Republic versus Orbecido, this honorable court said that what matters is the citizenship of the parties at the time of the divorce, not when they got married. In that case, the wife had become a naturalized American citizen before she obtained the divorce. That made the marriage a mixed one at the time of divorce, and so the Filipino husband could seek recognition of that divorce here. In Orbecido, the court fixed the date of divorce as the point when the existence of mixed marriages should be reckoned, expressly affirming its previous rulings, which subsequently found expression in paragraph 2 of Article 26. In Republic versus Manalo, the Filipino wife obtained a divorce from her Japanese husband. The court allowed her to seek recognition of that divorce in the Philippines, not because she was Filipino, but because the divorce was valid under the law of her foreign spouse. In both cases, the foreign element was present at the time of divorce. In contrast here, both petitioner and respondent were Filipino citizens when the divorce was obtained. That makes this a purely Filipino marriage, and under our laws, a foreign divorce between two Filipinos is simply not recognized. Petitioner argues that his later naturalization as an American citizen somehow cures the defect in the divorce, thereby making possible its enforcement in this jurisdiction. We respectfully disagree. The critical moment is when the divorce was obtained, and at that time, petitioner was still bound by Philippine law. Changing citizenship after the divorce does not alter the legal consequences of what was already done. It cannot validate a decree that was clearly void at the time of its issuance. Furthermore, petitioner's current dual citizenship reinforces our position, even as we admit that dual citizens have certain rights and privileges not otherwise enjoyed by those like us who hold only Philippine citizenship. That privilege should not extend to the enjoyment of rights that contravene our most fundamental societal values. Our law on dual citizenship is also clear on this point. Those who reacquire Filipino citizenship shall be subject to all attendant liabilities and responsibilities under existing laws of the Philippines. That includes being subject to our laws on family and marriage. Dual citizenship does not give someone the power to pick and choose which laws to follow depending on convenience. This honorable court should therefore be wary of opening a backdoor to absolute divorce between Filipino citizens. If we allow foreign divorce to be recognized just because a party later changed citizenship, we are undermining both the nationality principle and our state policy disallowing divorce. We also risk encouraging a trend where Filipino citizens go abroad, obtain a divorce, then switch citizenship to have that divorce recognized at home. That is not what the law provides, and it is not what the framers intended. This case does not have the anomaly in Orbecido or Manalo, where the Filipino spouse would remain married to a foreign spouse whose national law permits him or her to remarry by virtue of a validly obtained divorce decree. In this case, there is no foreign spouse. There is no valid divorce decree to enforce. there is no injustice to cure. Both parties remain subject to Philippine laws and remain married under our laws. The legal and moral consequences of their marriage remain in force. We respectfully submit that there is no basis, legal or equitable, for extending the exception in Article 26 to this case. To do so would be to go beyond interpretation and into legislation. Your Honors, marriage and its dissolution are undoubtedly issues of grave importance, but these questions are also the most contested issues which force us to dig deeper into our passionately held beliefs and our societal values. It is the understanding of this complexity that convinced the members of the Civil Code and Family Code Commissions almost 4 decades ago to leave such important questions for the legislature to resolve. For it is there where an open and unrestrained debate could be held and where all sides from the widest representation of opposing persuasions could be heard. Many continue to wait for a divorce law to pass. However, the question of enacting one is evidently political, reserved for both houses of Congress to address. For now, Congress has seen fit to retain the narrow exception to our policy against divorce as expressed in paragraph 2 of Article 26 of the Family Code and as found in the Code of Muslim Personal Laws of the Philippines. We therefore ask this honorable court to uphold the clear intent and letter of paragraph 2, Article 26 of the Family Code, to affirm the continuing force of our policy on marriage and to deny the petition. Thank you, Your Honors.
Thank you very much, Solicitor General. May we call on Justice Adolfo Ascuna, retired, for his presentation.
Thank you, Your Honors. Good afternoon. I respectfully submit, Your Honors, that the solution to this case lies in the answer to 3 questions. The first question is, when did the Philippines become the Philippines? The second question is, what does the Constitution say about the foundation of the nation? And the third question is, why is it that up to now, the Philippines is the only member of the United Nations that does not have a law of absolute divorce available to all its citizens? The first question, Your Honors, was posed to me at a state dinner in Japan by a lady member of the Supreme Court of Japan by the name of Ryuko Sakurai. Madam Justice Sakurai was seated beside me in a dinner for the Crown Prince in the University of Kyushu. And she asked me, Justice Ascuna, would you answer a question? Yes, madam. And she posed, when did the Philippines become the Philippines? I had to pause for a few seconds. Then I remembered Dr. Jose P. Rizal was the first Filipino. I remembered the definition of a nation by Benedict Anderson, that a nation is an imagined community. And it was Dr. Jose P. Rizal whose writings sparked the imagination of our people into a nation. And so my answer was, in the early morning, at 6 in the morning of December 30, 1896, madam, because that was when they shot our national hero at the Luneta, giving birth to the Filipino nation. The writings of our national hero, which, by the way, according to Father de la Costa, the Philippines probably is the only nation that has for its national hero a scholar. Dr. Rizal, as a scholar, wrote the first historical treatise that considered the Philippines apart from Spain. That was his annotations to the Sucesos de las Islas Filipinas of Antonio Morga. That was in 1889. Subsequently, in his writings, including his two transformative novels, Noli and Fili, he introduced the idea of the specter of comparison. When Crisostomo Ibarra was walking among the gardens of the Philippines, he remembered the gardens of Europe, and he compared the Philippines under colonial rule with a free Europe. And that was the birth, again, of our consciousness, our imagination as a nation. So that's the answer to the first question. The second question is, we go to the Constitution. What does the Constitution say is the foundation of the nation? The Honorable Solicitor General told us that the Constitution says that marriage is the foundation of the family. In fact, the Constitution says that marriage as an inviolable social institution is the foundation of the family. But that is not my point. My point is the previous section, Section 1 of Article 15, which says that the foundation of the nation is the Filipino family. The Filipino family is the foundation of the nation. And marriage as an inviolable social institution is the foundation of the family. Therefore, marriage as an inviolable social institution is the foundation of the nation. And so therefore, when we erode the nationality principle that is embodied and enshrined in the Constitution, we erode the very foundation of the nation. Finally, why is it that until now, the Philippines remains, aside from the Vatican, as the only nation that does not have a civil divorce legislation, apart from the exception given to our Muslim brothers under executive order of President Marcos? The reason, Your Honors, is because of our strong public policy that marriage as an indissoluble, inviolable social institution is the foundation of the family and the Filipino family, not just family. The Filipino family is the foundation of the nation. I asked one of the young solicitors earlier while we were waiting, what does the Constitution say is the foundation of the nation? And if she had answered, she did answer it. She was brilliant. She did say. But if she had answered, and if I asked this in the bar exams, and the answer is the family, wrong. Constitution does not simply say that the foundation of the nation is the family. It says the Filipino family. It introduces nationality to the foundation. So our nation is founded on the nationality principle. That is why Article 15 of the Civil Code anchors the conflicts rule on Filipinos, even living abroad, as being governed by our national law. I had the occasion, Your Honors, to play a role in the crafting of the exception to the nationality principle that is found in Article 26, Paragraph 2 of the Family Code. I was then the Presidential Legal Counsel of President Corazon Aquino. And former Justice Florida Ruth Romero was also a special assistant to the President. President Aquino tasked her to craft a family code because at that time there was a strong pressure from social groups to update our rules on marriage. So a commission was formed in order to craft the family code. But that commission did not recommend an exception to the general rule that there's no divorce among Filipinos. But President Aquino instructed Justice Romero to look for a possible exception in order to solve the dilemma in the Van Dorn case. Recall, Your Honors, the Van Dorn decision, which was penned by the late Justice Amorpina Melencio Herrera, where she said that a husband without a wife or a wife without a husband is an anomalous situation unknown to law. And that is a situation that happens when a foreigner and a Filipino marry and later the foreigner obtains a divorce, a valid divorce, allowing the foreigner to remarry, but leaving the Filipino unable to remarry. A husband without a wife, or a wife without a husband. President Aquino wanted Justice Florida Ruth Romero to solve that dilemma by crafting a provision that will address it. And we discussed it, Your Honors. I told Fleury, because I was teaching conflicts of law at that time, there are two possibilities: the Austrian model and the Brazilian model. Under the Austrian model, if there is a mixed marriage of an Austrian and a foreigner, and the foreigner obtains a valid divorce, the Austrian rule is they will not allow the Austrian to remarry. On the other hand, the Brazilian rule is if a Brazilian marries a foreigner and subsequently the foreigner obtains a valid divorce, allowing the foreigner to remarry, Brazil allows the Brazilian citizen to remarry. That was the model that Florida Romero, Justice Romero, followed and recommended to President Aquino, and that is what is found in Article 26, Paragraph 2. The essential requisite is mixed marriage. It has to be between a Filipino and a foreigner because it's an exception to the rule. The rule is two Filipinos, no divorce. But if one is Filipino, another is a foreigner, there is a possibility of recognizing the effect of the divorce by allowing the Filipino to remarry. That is Article 26, Paragraph 2. That article, Your Honors, has undergone several transformations. The first is the Orbisido case, where two Filipinos married, but later on, one of them became a foreigner, and they obtained a divorce, valid divorce. It was ruled that the exception applies, even if the premise did not obtain. There's no marriage between foreigner and Filipino. They were both Filipinos when they got married. But in Orbisido, they said, as long as they were foreigner and Filipino at the time of the divorce, the exception applies. The second transformation was the Manalo case. The article requires that it is the foreigner who obtains the divorce, not the Filipino. And Manalo said, because of the equality among sexes, even if it's the Filipino who obtains the divorce, it's still applicable. But the cardinal rule must always be that the divorce is between mixed spouses, one Filipino, one foreigner. Why? Because if they're both Filipinos, the rule will apply, Article 15. not Article 26, paragraph 2. So if we allow two Filipinos to obtain a divorce while they are Filipinos and recognize it regardless of what happens afterwards, we will be applying the rule, changing the rule, not merely expanding the exception, but changing the rule, and we will be undermining the foundation of the nation. Thank you, Your Honor.
Thank you, Justice Escuna. May we call Attorney Elizabeth Aguiling Pangalanan?
Good afternoon, Your Honors. The case before the court is a conflict of laws case because it contains a foreign element. And in discussing and analyzing conflict of laws cases, there are two possible approaches, Your Honors, and these are the traditional approach and the second is the modern approach. Counsel humbly presents before the Honorable Court these doctrinal options that the court may wish to take in its decision. I first discuss the traditional approach. Under the traditional approach, courts characterize a case under a specific substantive area of law and applies the law to this event or transaction. The applicable law consistently governs these substantive issues wherever the case is brought. Therefore, the traditional approach aims to achieve simplicity, convenience, and predictability of result. The traditional approach to choice of law involves the application of lex nationali for issues relating to family rights and duties, status, conditions, and legal capacity, as found in Article 15, and this applies to Filipino citizens, including those living abroad. Philippine laws do not provide for absolute divorce, and this is considered contrary to our concept of public policy, as explained in the Chavez case and the Van Dorn versus Romilia case. However, Article 26, paragraph 2 of the Family Code serves as an exception to the nationality principle provided in Article 15 of the Civil Code. As originally intended, Article 26, paragraph 2 was narrowly applied to a mixed marriage where at the time of the celebration of the marriage, there was a foreigner and a Filipino. However, the Supreme Court in Republic versus Obrecido expanded the applicability of Article 26, and I quote, taking into consideration the legislative intent and applying the rule of reason to include cases involving parties who at the time of the celebration of the marriage were Filipino citizens, but later on, one of them becomes naturalized as a foreign citizen and obtains a divorce abroad. In Republic versus Manalo, the court further broadened the application of Article 26, paragraph 2 to cover mixed marriages where a divorce is validly obtained abroad by the Filipino spouse, capacitating the alien spouse to remarry. Following, therefore, the traditional approach to choice of law, the Family Code and the Civil Code of the Philippines will be applied. The divorce obtained abroad by the petitioner prior to his obtaining an American citizenship is not a valid divorce and hence will not be recognized in the Philippines. Allow me, however, Your Honor, to spend some time discussing the other approach to choice of law. The court may use a modern approach to choice of law when the case raises a question as to whether the governing law is the forum court's own law or the appropriate alternative, usually foreign law that should apply. And this one such modern approach, Your Honors, is the most significant relationship test. Where the facts establish that the most significant connection is with another state, the Honorable Court has decided in Hasegawa versus Kitamura that under the state of the most significant relationship rule, to ascertain which state law to apply to a dispute, the court should determine which state has the most substantial connection to the occurrence and the parties. End of quote. The Supreme Court has also held in several cases that the law to be applied varies depending on the circumstances and that those circumstances will serve as the connecting factor in determining the applicable law. Applied to this present test, Your Honor, the court may find the relevant connecting factors to include inter alia the parties' nationalities, the domicile of the petitioner, domicile of the respondent, the marital abode at the time of the divorce, and the place of employment. Under the modern approach, the rights and obligations of the parties are determined by the law of the state, which has the most significant relationship to the occurrence or event and the parties. Although Petitioner Baluyot is both a Filipino and an American, he has other substantial contacts with the U.S., namely his domicile that has the closest personal connection in matters of domestic life, as well as his place of employment. Furthermore, Baluyot lives in the U.S., whose courts grant and recognize divorce. So, although he may wish to comply with the requirements of Article 26, Paragraph 2, now that he is an American citizen, that petition for divorce that he may file as an American will simply be thrown out. The Superior Court, of California already issued a divorce judgment in 2010, and it will be absurd for another court to dissolve an already dissolved marriage. Moreover, Your Honors, even if the California divorce decree is not recognized in the Philippines, Baluyot will return to the U.S., as in fact he is still there right now, live his life there, where as a divorced American citizen, he will be able to remarry. This situation will thwart the very purpose of Article 26, Paragraph 2, which is to avoid the ridiculous, absurd, curious situation of a foreigner no longer married to the Filipino, but the Filipino still married to the foreigner. It is worth noting, Your Honors, that Article 26, Paragraph 2 does not contemplate a scenario where one or both of the parties are dual citizens. It just refers to an alien and a Filipino, but it does not contemplate a situation where one of the parties is both an alien and a Filipino. It did not anticipate that more than a decade later, about 15 years, the dual citizenship law will be passed. Article 9 of the Civil Code of the Philippines provides that no judge shall decline to render judgment by reason of silence or insufficiency of law. Where there is no existing law in the forum, therefore, the court can apply the modern approach, and although ideally all choice of law theories should advance both justice and predictability, they do not always do so. Given these, the court may consider informing Congress of the present lacuna in the law. The current state of Philippine law callously disregards the plight of migrant Filipinos who in 2022 numbered 1.2 million and who struggle to create better lives for themselves outside of their country, and yet who remain connected to the lives of their families and countrymen in our homeland. As it is, the failure of our legislature to address this lacuna unfairly shifts the burden to our courts, and especially our Supreme Court justices, to constantly have to adapt and readapt the legal straitjacket to enable Filipinos who have been living and working abroad to exercise the rights and enjoy the benefits available in their adopted countries that are ironically denied them by unrealistic laws of their country of birth. As to the last point, Your Honor, the recognition of foreign divorce decree in the present case is not necessarily contrary to Philippine public policy. I hereby submit that the standard of public policy must be higher, as we see in the Hague Conventions, which require manifest incompatibility, or that the fundamental principles of the requested state relating to the protection of human rights and fundamental freedoms. Thank you very much, Your Honor. I see that my time is up.
Thank you, Attorney Pangalanan. May we call Attorney Melesio Santamaria?
Good afternoon, Your Honors. Is it time to abandon the rule that a foreign divorce obtained by two Filipinos abroad is against public policy and morals, and therefore void and not recognizable? Your Honors, it is time to abandon that outdated precedent. The freedom to choose one's status is a privilege inherent in a person as an intangible and inalienable right. Allow me to state the following points. First, there is no need for any legislation amending our present laws in identically conforming to a foreign law, in this case, the California Family Act of 1969. As a unique, special, and extraordinary judicial remedy, it is the petition for recognition of foreign judgments' basic premise that foreign laws, judicial decisions, and their effects, not having any Philippine counterpart, can be enforced locally if the effects are not violative of any Philippine prohibitory or mandatory law or any overriding Philippine public policy and morals. The remedy's availment is a fundamental constitutional right of every Filipino to correct his or her status. It is a part of customary international law. Second, the availability of three local Philippine remedies for marriage dissolution: nullity, annulment, termination by affidavit or reappearance, proves that Philippine public policy has always been open to the severance of marital ties between Filipinos. Article 26 of the Family Code and the Sharia law, in addition, demonstrate that absolute divorce per se is not offensive to our culture, tradition, and morals. Antonio versus Reyes, promulgated 19 years ago, enunciated, and I quote, "There is a corresponding interest of the state to defend against marriages ill-equipped to promote family life," unquote. Third, there is no prohibitory law and no mandatory law expressly disallowing absolute divorce between two Filipinos, here or abroad. Neither is there an overriding public policy against it. Both our Constitution and Family Code, the public policy statement on the protection of marriage, does not expressly refer to a prohibition against any kind of divorce or any danger thereof in particular, but to the institution of marriage in general. Marriage is an inviolable social institution. Our Constitution is a magnificent document. It provides aspirations, commands, and principles. There are two sections in our Constitution which says inviolable. The church and state, the separation shall be inviolable. That's a command. Marriage is a inviolable social institution. That is an aspiration. Because our Constitution cannot remedy all problems. And so that therefore the next sentence, and the state shall protect it. And so that therefore we have the Family Code to protect it. Fourth, Philippine law's omission or silence of a domestic or foreign divorce remedy between Filipinos does not signify an overriding public policy prohibiting the same. To be so, there must be a clear and positive statement of public policy against it. As Justice Marshall Harlan said, and I quote, "Legislative silence is a poor beacon to follow in discerning the proper statutory route," unquote. Justice Felix Frankfurter, in a case rejecting the creation of a principle by virtue of congressional silence, warned various consideration of parliamentary tactics and strategy might be suggested as reason for inaction of Congress, but they would only be sufficient to indicate that we walk on quicksand when we try to find, in the absence of corrective legislation, a controlling legal principle, unquote. To say that congressional silence creates a public policy is unsound. As Justice William Douglas said, and I quote, "It is at best treacherous to find in congressional silence alone the adoption of a controlling rule of law. The silence of Congress and its inactions are as consistent with a desire to leave the problem fluid as they are with an adoption by silence of the rule of those cases," unquote. And any legal principle resulting from an omission will only create a clearly fictional presumption in the light of the realities of the times. In that regard, it has been surveyed that today, 50% of Filipinos regard divorce as an issue of irreconcilability and not of morality and public policy. Fifth, in this regard, the case of Gabriel versus Monte de Piedad will teach us. It says, and I quote, "In the absence of express legislation or constitutional prohibition, in order to declare a contract void as against public policy, must find that the contract as to the consideration or things to be done has a tendency to injure the public, is against the public good, or contravenes some established interests of society, or is inconsistent with sound public policy and good morals, or tends to undermine the security of individual rights, whether of personal liability or private property," unquote. This guide can also be used for the determination or not of whether or not the effects of a foreign absolute divorce decision granted to two Filipinos is against public policy. Relevantly, Republic versus Cuevas Nang ruled that a foreign divorce by agreement, undeniably omitted or not provided in Philippine law, can be judicially recognized. It is, as the Supreme Court, this Supreme Court said, not offensive to public policy. To be against public policy, the effects must be so pernicious, detestable, fundamentally unjust, sufficiently outrageous, patently in violation of our core principles, or be so grave that recognition would be intolerable to our legal order. It must violate a deep-rooted tradition of the common will. The two Filipino party element in a foreign divorce will not lead to those situations. Senator Salonga, in his private international law treatise, said, and I quote, "Repeated use of public policy may be no more than an intolerable affectation of superior value," unquote. And he continued, "The statement that foreign law will not be applied when a strong or important public policy of the state will be infringed thereby does not, of course, furnish a precise solution. For as had been aptly stated, public policy is relative. It varies with changing legal ideas. Relatively ratione temporis. What might be against public policy yesterday may no longer be so now, and vice versa. A fixation on these outmoded public policy and moral arguments may preclude this court or any court to exercise its distinct power to re-examine the fairness of this concept in the light of prevailing circumstances." From the substantial similarity test referred to by American legal literature, which I call identity test, recognition of foreign judgment has changed to the effects test to determine its consistency with Philippine public policy. In the 1939 Sicat versus Canson case, actually, it's very early in our history, a foreign divorce was ruled as against public policy simply because the ground of desertion has no equivalent ground for marriage termination in Philippine policy. Solonga said that there is and I quote, there is a constant temptation on the part of Philippine courts to apply the domestic local law to all conflict rules. One of the reasons was, and I quote, he's saying this, just a simple case of bias in favor of Philippine law. Such approach exhibits a selfish provincial outlook, a case of judicial parochialism, overemphasizing local fancies. It is an easy way out approach used by the courts, or some courts, not this court, to shift responsibility to the legislature. In re Petition for recognition of divorce, Takahashi and Marona, the Supreme Court said, it should not turn a blind eye to the realities of the present time. It is hypocritical to safeguard the quantity of existing marriage and at the same time brush aside the truth that some of them are of rotten quality. In the United States, the identity test or substantial similarity test is now defunct. Fortunately, in subsequent cases, the Philippine Supreme Court likewise examined not the law or decision per se, but its effects in the Philippines. In Suzuki versus OSG, the Supreme Court ruled that in the recognition of foreign judgment, Philippine laws, and I quote, should not be pitted against the recognition of a foreign decree. Instead, the better course of action is to reconcile them and their effect in their respect and give effect to their respective purposes, unquote. Seventh, in Mr. Baluyot's case, the effects of the foreign judicial decree based on foreign law stated in the decision are this: marital dissolution, court custody, support, visitorial rights of children, termination of spousal support, separation of conjugal properties, all are consistent, if not exactly identical, with Philippine law. Indeed, what fundamental gain is it for the Philippines to refuse recognition and in so doing deprive deserving Filipinos of such effects not obnoxious or repugnant to Philippine law? 8. The Constitution Equal Protection Clause is violated by giving the chance of a favorable recognition between a Filipino and a foreigner on the one hand, but on the other hand, by assuring automatic rejection between a Filipino and a Filipino. Dito sa situation natin na ito, siguradong talo ka kasi Pinoy ka. The invocation of public policy will deny a remedy to Filipinos for what may be an injustice and an immuration in a relationship detrimental to their mental and physical health and well-being. The danger to our institution is to enhance or to carry on an obsolescent argument on public policy and morals. We have to look around. This is the distinctive power of the court in a petition for recognition of foreign judgment, to determine what is the public policy today by looking at the facts, looking around us, and then decide. And I submit, Your Honor, that it is time to abandon this outdated public policy and moral doctrine. Thank you.
Thank you, Attorney Santa Maria. May we call Attorney Maria Liza Lopez Rosario.
Good afternoon, Your Honors. There are 3 laws that appear to be applicable in the present case. One is Article 26, Paragraph 2 of the Family Code. The second is Article 15 of the 1950 Civil Code. And the last one is the Dual Citizenship Act. Now, even in law school, we always tell our students, let's look at the legislative intent. So, allow me to look at the legislative intent behind Article 26, Paragraph 2 of the Family Code. As a matter of fact, if we will take a look at the time when the former President Corazon Aquino signed it into a law, July 6, 1987, the second paragraph of Article 26 does not appear. But then, July 16 of 1987, the members of the Family Code Committee convened. When the Undersecretary Romero informed them that the President already agreed or consented to the inclusion of this provision, and what is the rationale behind that? To give a Filipino national married to a foreign spouse the opportunity to marry if under the national law of the foreign spouse, divorce is accepted. And as mentioned by Justice Ascuna earlier and by our Madam Solicitor General, Article 26, Paragraph 2, for it to be applicable, should refer to mixed marriages, meaning to say a foreigner and a Filipino spouse. But in addition to that, as pointed out by Dean Carale during that meeting, the provision, rather, it was Dean Carale who also pointed it out, the provision is limited to a Filipino who is married to an alien. Professor Bautista said, it is the foreigner, not the Filipino spouse, who will seek for divorce. And the underlying reason behind that, as mentioned by Judge D at that time, is the legal absurdity for one to stay married without a spouse. Now, the case of Baluyot involves two Filipino nationals. So obviously, Paragraph 2 of Article 26 does not apply. However, what makes the case of Baluyot complicated is that after getting a decree of divorce, Baluyot became a naturalized American citizen. And therefore, at this point, I think we can use, by analogy, the ruling of the Honorable Court in the case of Republic versus Orbecido. Because similar to the case of Baluyot, wherein the husband and the wife were both Filipino national at the time that they contracted marriage, in the case of Orbecido, both of them were also Filipino national. It just so happened that the wife became a naturalized American citizen prior to getting a decree of divorce. Now, at this point, what laws should we apply? Is it the second paragraph of Article 26? In my humble opinion, I think it's the application of Article 15 of the Civil Code. And what does Article 15 of the Civil Code says? When it comes to family rights, family duties, status, condition, legal capacity, you have to apply the national law of the person. So, at that point, when the wife of Orbecido obtained the decree of divorce, it's not anymore the Philippine law that should apply to her, but it is her national law. So if Baluyot did not reacquire Filipino nationality, Baluyot could not have any problem. Applying by analogy the ruling in Orbecido, that would suffice. For as long as Baluyot could prove to this honorable court that when he became an American national, his American nationality recognized the decree of divorce that he obtained even before he became an American national. Now, petitioner cited several cases, and if I may be allowed to mention them, the cases of Fujiki, Tanaka, Nan, Manalo, and Galapon. But I beg to disagree that they are applicable in this case. Why? because all of these cases involve mixed marriages. A Filipino married to a Japanese, a Filipino married to a Korean national. It just so happened in the case of Manalo, it's not the Japanese national who obtained the decree of divorce, but it was the Filipino spouse. So in a way, there is a change in the legislative intent. And that's the reason why I advise the Honorable Court, if it's possible, to call the attention of Congress and Senate to make the necessary amendment so that the decision of Manalo can coincide with that of what appears in the Family Code. Because we're talking here of a 1987 code. Now, later on, and this gave Manalo or Baluyot the problem, he reacquired Filipino nationality. The problem with our Dual Citizenship Act, with due respect to the proponent of the bill, I think everybody knows in this room that it is only when it comes to the reacquisition of political right, and even in its implementing rules, that the law is very clear that a Filipino, a former Filipino national who reacquired or retained his Filipino nationality, in the event that he wants to run for public office, he has to renounce the other nationality. But I think the legislators overlook the fact that there are countries wherein the civil rights in the Philippines are different from the civil rights in another country. I can see that we have students here in civil law, and they're aware of the case of Aznar versus Christensen, wherein in that case, the right of an illegitimate child in the Philippines is different from the right of an illegitimate child in the United States. And there's a reason why the illegitimate child is claiming it has to be the Philippine law that should apply. Although in the case of Christensen, he's an American national. But the national law of America reverted the issue to Philippine law, and that's where we were introduced the Rinva Doctrine. That's why I also recommend that I think it's proper that legislators should also take a second look of this Dual Citizenship Act, because they might be abused by some Filipinos. I rest my case. Thank you very much.
Attorney Rosario, may we call Attorney Maria Calvina T. Ligarda?
Good afternoon, Your Honors. Your Honors, a divorced person is legally single, and this was stated in the case of Atherton, cited in Van Dorn, and somewhat recognized by Justice Puno during the deliberations on March 2, 1985, when Justice Ed Kagiwa proposed to add the phrase, in case the party is an alien, after the parenthesized single widow or widower divorced, and Justice Puno opined that divorced may be deleted since one is legally single if he or she is divorced. When Mr. Baluyot obtained the divorce decree, his so-called adopted country dissolved his marriage and his marital status reverted to single. When he retained or reacquired his Philippine citizenship, his marital status continued to be single. The reacquisition of his Philippine citizenship does not invalidate, revoke, or eliminate the divorce decree obtained in the United States, nor does reacquisition of Philippine citizenship confer renewed marital status upon him. It is absurd, respectfully, that by virtue of reacquisition or retention of Philippine citizenship, Mr. Baluyot suddenly reverted to the marital status of married. As pointed out by my colleague in the UP, Professor Pangalangan, he can no longer obtain another divorce decree in the United States of America because he is divorced. My next proposition is the same question asked, is divorce really against public policy? I know that many decisions of the Honorable Court say so. But as observed by Justice Luciano during the deliberations on the Family Code, and that was in the 1980s, present laws have become irrelevant to today's changing morals, and that the Church itself has amended canon law to broaden the base of declarations of nullity of marriage. As further observed by Justice D during the same deliberations, before 1950, she observed, the court was using the Spanish Civil Code, and the influence of the Church was very strong because there was then a union of church and state. And contrary to the fears of J.B.L. Reyes, during the same deliberations, the rich and the wealthy have not sought divorce abroad. Those who are obtaining divorce decrees are the Filipinos who work abroad, the OFWs, and we prejudice them by not allowing this particular divorce to be recognized. Today, Your Honors, as ruled in Republic versus Manalo, there is no general prohibition on divorce because Commissioner Gascon, in response to a question by Father Bernas during the deliberations of the 1986 Constitutional Commission, was categorical about this point. And more importantly, none of our law should be based on any religious law, doctrine, or teaching. Otherwise, the separation of church and state will be violated. Is it so against public policy that the court will not provide relief to a Filipino citizen who obtained a foreign divorce decree, became an American, and then reacquired Philippine citizenship? Marriage has civil and legal consequences which are governed by the Family Code. It is in this aspect, bereft of any ecclesiastical overtone, that the state has a legitimate right and interest to oversee. When an issue involving a marriage comes before this court, the issue refers only to a civil marriage, not the sacrament of marriage. To state the obvious, when a man and a woman marry in Catholic rites, two separate events occur. Should all essential and formal requisites under the Family Code be present, the marriage is valid under Philippine law, civil law. And under Catholic doctrine, a matrimonial covenant is established under the Code of Canon Law 1055. I'm not an expert on canon law. I bow to the expertise of Dean Lopez Rosario on that. However, I understand from a document entitled Propositions on the Doctrine of Christian Marriage that the International Theological Commission of the Holy See in 1977 propounded, and I quote, "In a pluralistic society, the public authority of the state can impose on the engaged a public ceremony through which they publicly profess their status as spouses. The state can furthermore make laws that regulate in a precise and correct manner the civil effects deriving from marriage, as well as rights and duties regarding the family." And that is the role of the Family Code. Then the Commission intoned, and I quote, "The Catholic faithful ought to be adequately instructed that these official formalities, commonly called civil marriage, do not constitute real matrimony for them. The matrimonial covenant or sacrament of marriage may only be dissolved by nullity under the Code of Canon Law 1095. Catholic doctrine treats a sacramental marriage as indissoluble, and the indissolubility of marriage emanates from its nature as a sacrament. The Honorable Court may even take judicial notice of the fact that even when a Catholic marriage has been nullified under the Family Code, the couple, unless they seek redress from the National Appellate Matrimonial Tribunal of the Catholic Church, are still bound to their sacrament of marriage. Civil marriages do not have such sacramental meaning. A civil marriage may be dissolved either through nullity, annulment, or a decree of divorce. It would be egregious error to treat the standard of indissolubility under Catholic dogma as applicable to civil marriages. Marriage, as recognized in the Constitution and defined in the Family Code, is civil in character because it is established by the state independent of its religious aspect. And the court, if I may, must endeavor to preserve such distinction in its analysis and in adjudication. In Republic versus Molina, the court recognized the separation of church and state and merely declared that findings of the National Appellate Matrimonial Tribunal must be given respect as these findings relate to civil marriages, but they have never been followed in any decision of this court. The Catholic Church, aside our country, has historically authorized divorce. In 1917, the divorce law on 2 grounds. During the Japanese occupation, when Senator Tolentino obtained his divorce, and again when the Commonwealth government was revived by proclamation of General Douglas MacArthur on October 23, 1944, the divorce law of 1917 was also revived. The existence itself of the second paragraph of Article 26 demonstrates that divorce can be recognized and given effect in the country. The Code of Muslim Personal Laws continues to recognize the divorce of Muslims, and its continued existence in our statute books manifests that the blanket argument that Philippine law has a public policy against divorce is untenable. The court must reject respectfully any previous or current attempts at repeating the mistaken notion that there exists under Philippine law public policy against divorce, because there is none. And finally, lest the bell rings, Van Dorn is still good law today. Van Dorn preceded the Family Code and the 1987 Constitution. In Van Dorn, the divorce decree was recognized even though it was obtained by the Filipino spouse. There was no need for Article 26, which, as applied today, has resulted in discrimination against former Filipinos and dual citizens. And maybe it is time for the court to consider Article 26, Paragraph 2 as unconstitutional for being violative of the Equal Protection Clause. I do know that the conservatives in the committee wished to exclude Paragraph 2 because Justice J.B.L. Reyes stated that the second paragraph discriminates against Filipinos who are married to Filipinos because the provisions governs only Filipinos married to foreigners. Article 26 was inserted by an executive order prior to the signing of the Family Code by Florida Ruth P. Romero, who was my professor in persons in UP. And therefore, you will notice that the Family Code makes no statement as to the consequence of that divorce, as to children, as to marriage, as to property regimes. Nothing. Unfortunately, in 2005 came the case of Eoy, where the court passed over the fact of a divorce, stating that divorce obtained by Mrs. Ioy cannot be considered as she was still a Filipino when she obtained it. The social impact of Ioy, it would be interesting to study. Crassus Ioy is still married to Feli. They both remain compulsory heirs to each other. They are obliged to follow marital obligations like support and living together, and it is absurd. Mrs. Ioy is abroad. Can Mr. Baluyot, therefore, a former Filipino, obtain a divorce while still a Filipino? Why not? He is now a naturalized citizen of a foreign country. That he retained or reacquired Filipino citizenship has no impact on the fact that he is now single. That is fair and equitable to all concerned. His children, if any, with his former spouse remain legitimate. Subsequent marriages will be valid. The children, if any, of subsequent marriages will be legitimate. Neither spouse will be an heir of the other. Neither spouse will be required to continue their marital obligations, and neither spouse will be permitted to share in any profits from their businesses or in properties acquired. As the court has said, a balance between the word and the will, that justice may be done even as the law is obeyed, may be used today. It is respectfully prayed, therefore, that the court recognize this particular divorce, and especially it rule, if it cannot, it rule on a pro hac vice basis in favor of the recognition of the divorce obtained by Mr. Baluyot, not for his sake, but for the sake of his former wife, Maria Fe Antonio Baluyot, who is stated or described in the petition as married, but not to Mr. Baluyot. Her silence should not be taken against her when it is not altogether outside the realm of possibility that she relied in good faith on the assurances of Mr. Baluyot that he had already obtained a divorce decree abroad, severing their marital ties. Thank you, Your Honors. Respectfully submitted.
Thank you, Attorney Carolina Ligarda. May we call Attorney Eliezer Ambatali? Sige. Ano to? Sa...
Good afternoon, Your Honors. On behalf of Undersecretary Claire Dennis Asmapa, the National Statistician and Civil Registrar General, I respectfully submit our intervention grounded in our engagement with civil registration systems, their legal frameworks, and their essential role in upholding the citizen's identity, recognition of status, and protection and enjoyment of rights provided by law. I offer this perspective in this hope of aiding the court in its deliberation on how best to reconcile statutory provisions with constitutional mandates and broader public interest. With the court's indulgence, let me submit our 4 key considerations that may be pivotal in the resolution of this case and its impact in civil registration systems. First, the central role of the civil registration system and the need to preserve the reliability and legal integrity of civil registry documents, which serve as the foundation of civil status and/or legal capacity. Second, the application of the nationality principle in the context of marriage license, or application of marriage license, specifically where one or both parties are foreign nationals, and how this intersects with the state's regulatory interest in the marriage solemnization. Third, the recognition of foreign decrees and judgments, particularly in relation to personal status, under the principle of lex nationali, in harmony with the provisions of Republic Act No. 9225 on the retention and reacquisition of Philippine citizenship. And finally, the steps being followed in the registration of foreign divorce in the civil registry database in adherence to established procedures for purposes of curbing the occurrence of fraud. Each of these points bears the statutory framework governing civil registration and personal status. Let me start by saying that the civil registration system serves as the primary repository of a person's personal vital events. Under Section 13 of Act Number 3753, civil registry documents such as certificates of live birth, marriage, and death are public documents and prima facie evidence of truth of the facts they contain. These are relied upon in both public and private transactions as sufficient proof of identity, civil status, and other personal data. Finally, once the vital event, such as a celebration of marriage, is registered, it is clothed with regularity, meaning all necessary due diligence was done and was processed within the prescribed procedures as provided under prevailing laws, rules, and regulations. I would like to highlight the difference in the requirements of availing a marriage license between Filipinos and foreign nationals. For Filipinos, he must present proof of identity which comes from a birth or a baptismal certificate. He must also prove that he is single by submitting a PSA-issued certificate of no marriage. If previously married, they must present a death certificate or a judicial decree of annulment, nullity, or divorce duly recognized in the Philippines. For applicants whose ages are from 18 to 25, he must secure parental consent or advice, whichever is applicable, and attend marriage counseling consistent with the family code. However, for foreigners, if he's going to present his proof of identity, he must present his valid passport, proof of singleness, which comes from his own government, by presenting a certificate of legal capacity issued by their embassy or consulate, as required by Article 21 of the Family Code. If previously married, he must also present documentary proof of the dissolution of his prior marriage. In essence, the distinction between between the Filipino and foreign nationals is that Filipinos have more documentary requirements as opposed to that of the foreigner. Under the lex nationali or nationality principle, a person's family right, status, and legal capacity are governed by the laws of his or her nationality. This was also seen under Article 15 of the new Civil Code, which provides that laws relating to family rights, duties, or to the status, condition, and legal capacity of persons are binding upon citizens of the Philippines even though living abroad. Accordingly, Philippine citizen, even if residing abroad, is bound by Philippine laws on marriage, capacity, and impediments. As to a person of a dual citizenship, we think that he or she is considered a national of both countries. The principle is that such an individual's personal status and capacity are subject to the laws of each nationality. In the Philippine context, Republic Act 9225, or the Citizenship, Retention, and Reacquisition Act, expressly recognizes that natural-born Filipinos who reacquire or retain Philippine citizenship enjoy full civil and political rights as Filipinos without prejudice to their obligations under the laws of their other country of citizenship. If we put into diagram, the dual citizenship is situated in the middle of the requirements of the Filipino and foreigner. We are of the opinion that a dual citizen must comply with both the requirements prescribed by the Philippine law and the US, or the foreign country where he is a citizen. The family code is clear. If the local civil registrar knows of any impediment, it must be recorded. Yet, unless a court intervenes, the license is still issued. This is where the systems of reliability hinges not just on documents, but on the truthfulness of the declarations of the individual applying and probing and conduct of due diligence on the part of the local civil registrar. We would like to note, however, that in terms of the submission of a certificate of legal capacity, the U.S. Embassy has submitted or informed the Philippines that they are unable to produce a certificate of legal capacity as provided under Article 21 of the Family Code. The reason being is that the U.S. has no centralized registry of marriage, and therefore, the document that they are presenting to our local civil registrars is an affidavit in lieu of the legal capacity. Lastly, as I've said, pursuant to Article 18 of the Family Code, when there are known impediments, the marriage license will still be issued, but there are notes of the impediments. This is applied for Filipinos, foreigners, and dual citizens. On the recognition of foreign decree of divorce, the rules on marriage licenses apply differently when one of the parties is a foreigner. Philippine nationals are bound by the policy against absolute divorce. As the court ruled in Van Dorn, absolute divorce is considered contrary to public policy and morality for Filipino citizens. However, the law makes a distinction in mixed marriages. Under Article 26, Paragraph 2 of the Family Code, if a valid marriage exists between a Filipino and a foreigner, and the divorce is thereafter validly obtained by the alien spouse capacitating that spouse to remarry, then the Filipino spouse is likewise allowed to remarry. In the case of Orbicido, the court clarified that Article 26, Paragraph 2 of the Family Code covers cases where both parties are Filipinos at the time of marriage, but later on becomes a foreign citizen and secures a valid divorce abroad. The critical factor is citizenship at the time the foreign divorce decree, not at the time of marriage. Put simply, the effect of divorce depends on the nationality at the time it is obtained. In Corpus versus Santo Tomas, the court held that an action under Article 26, Paragraph 2 of the Family Code goes beyond merely recognizing the foreign divorce decree. If the decree validly capacitated the alien spouse to remarry, the Philippine courts may declare that the Filipino spouse is likewise capacitated to enter into another marriage. However, the court was clear, our jurisdiction does not extend to declaring alien's capacity. This is governed by his national law. Philippine courts can only recognize its effect on the Filipino spouse. Under Republic Act Number 9225, natural-born Filipinos who reacquire their Philippine citizenship are deemed never to have lost it. And with it, they remain bound by the Philippine laws even prior to the reacquisition of Filipino citizenship. The Supreme Court in Van Dorn again has made it clear that Philippine nationals are covered by policy against absolute divorce as it is contrary to public policy. Therefore, if a dual citizen obtains a divorce abroad, such divorce may not be recognized in the Philippines, since his legal capacity continues to be bound by the Philippine law. It is our view, Your Honors, that a dual citizen enjoys the rights of both countries, but also bears the duty to follow both laws. He cannot simply pick which law benefits him, because that would give one supremacy over the other. A foreign divorce decree cannot simply be registered in the Philippines. It first needs judicial recognition by our courts. Without it, any registration is void and produces no legal effect. That's why the PSA has issued Memorandum Circular number 2025-06, which states that once a foreign divorce is recognized in the Philippine court, the civil registrar or the local civil registrar has 10 days to register it at the local civil registry office. Then a certificate of registration and authenticity will also be issued and annotated on the original civil record and forwarded to the Civil Registrar General. In conclusion, we say that at the time of divorce was obtained, both parties were still Filipinos. Under Orbisido, what matters is their citizenship at the time of the foreign decree, not at the time of marriage. Based on the facts of the case, the divorce was obtained by one of the spouses even prior to his naturalization as an American citizen. Assuming that he was already a U.S. citizen when the divorce was obtained, the same will still hold no water pursuant to RA 9225. The reason being is that he still retained his Philippine citizenship. He is still bound by Philippine law, which does not recognize divorce between Filipinos. Thus, the foreign divorce decree cannot be recognized here. However, we would like to state that this case highlights a gap in our present legislation. While the Family Code provides guidance, it does not fully resolve the situation of parties caught between conflicting laws of different nationalities. In such situations, the court may take prudent step of bringing this issue to the attention of the Congress for the immediate enactment of laws that directly addresses this conundrum. As the agency mandated also with the technical supervision of civil registration, we are hoping that this court provide clarity on this case, particularly that the resolution of these cases have an impact on how we craft issuances in the registration of vital events and its implementation at the local level. Philippine law, consistent with long-standing public policy, prohibits absolute divorce between Filipino citizens, recognizing only annulment and legal separation. This strict prohibition, however, is not deeply rooted in our legal tradition. Under the Spanish regime, while absolute divorce was not permitted, legal separation was recognized. It was during the American and Japanese occupations or periods that absolute divorce was allowed under specific grounds. Given this historical context, Congress may well be advised to rethink its current position on the dissolution of marriage. Thus, it may be time for Congress to reconsider this policy and craft a more responsive legislative framework, one that respects the sanctity of marriage while providing realistic remedies for marriages that have irreparably failed. Thank you, Your Honors.
Thank you, Attorney Ambatali. Considering the presentations made, Justice Samuel Garland will commence his interpellation.
Thank you, Mr. Chief Justice. An awesome afternoon to everybody. Now, may I call on Attorney Melvin De Castro, the counsel for the petitioner, to take the restroom and answer my questions. Okay. Attorney De Castro, is this your first time to appear and argue before this court?
Yes, Your Honor. Actually, I even came from United Kingdom just last night.
Okay, so
this is the very first time, Your Honor.
So congratulations.
Thank you very much, Your Honor.
Now, you stated in your petition as to the status of the respondent, the wife, as married. Are you saying that she has remarried?
No, Your Honor. No, Your Honor. as far as I know, she's still, because my understanding is that until the case or the divorce was recognized, the status quo will remain the same. And technically, Your Honor, without the recognition, it still has no effect. And that is purposely, I still have to describe respondent as married, Your Honor. In the same token, that the petitioner, as I described, is also married, Your Honor.
So despite the fact that a divorce decree was already issued in the United States?
Yes, Your Honor. And for the record, Your Honor, although it's extraneous information, the respondent is also already married to a Filipino-American in the United States as well. Therefore, there is no consistency in describing petitioner as married in all my pleadings, Your Honor.
Okay. Is she also a naturalized American citizen?
Yes, Your Honor. The wife of the petitioner is likewise a Filipino-American.
So she's also a Filipino-American?
Yes, Your Honor.
Which means she's also a dual citizen?
I'm not so sure, but no, as far as I understand, she's a Filipino-American, but she hasn't obtained the dual citizenship.
When was she naturalized? Was it before the decree of divorce was issued, or after?
For clarification, are we referring to the
respondent?
The respondent. Actually, Your Honor, the respondent, actually my client is the petitioner, Your Honor.
Yes, but because if she is in a naturalized American citizen before the decree of divorce, then it will already be a mix. Manalo will now apply in that case.
No, the respondent is still a Filipino, Your Honor. It's actually the petitioner who actually become the American citizen. The petitioner.
It was the petitioner who was naturalized?
Yes, Your Honor.
How about the wife?
No, as far as I know, no, Your Honor. She remains in the Philippines.
Maria Fe Antonio?
Yes, she remains in the Philippines.
She remains in the Philippines?
Yes, Your Honor.
Okay. So, why is petitioner having his divorce recognized here in the Philippines? What is his particular or ultimate purpose? To remarry? Or?
Yes, Your Honor. Technically, my client, who happens to be petitioner, is already married in the United States and already married, and the wife somehow also want to have another marriage in the Philippines, Your Honor. And they're very much familiar and aware that they cannot do that, given the fact that the foreign divorce obtained by the petitioner has not yet been recognized in the Philippines.
Okay. Why did the petitioner reacquire Philippine citizenship?
If I'm not mistaken, sometime in 2010.
Yes, that was less than a year after becoming a naturalized American citizen.
Yes, Your Honor. Bear with my words. I'm just going to make
do you know of any reason why she reacquired Philippine citizenship?
To be honest, I'm not aware of. Because my wife is also happens to be also former Filipino. But whether they're going to take, it's gonna be, they decide whether to take a dual citizenship. It's more personal than her. And my contact is just limited only to the petitioner, Your Honor.
Yeah. If he did not reacquire Philippine citizenship, or he did not become a dual citizen, okay, is there a need for him to file a recognition of his divorce decree, of his divorce?
Again, I'm sorry, I did not get it, Your Honor.
What I'm trying to say is that if he did not reacquire Filipino citizenship, so he is not a dual citizen, but an American citizen, being a naturalized American citizen, is there a need for him to file a petition for recognition of his a foreign judgment or the divorce decree?
Strictly, Your Honor, no, there is no need, considering the fact that his capacity or the personal capacity to remarry will be in accordance with the American law, given the subsequent acquisition of the American citizenship.
Has petitioner renounced his American citizenship, if any?
Well, I'm not familiar with American law, but I think even if we can make it in the Philippines to renounce Philippine citizenship, I don't believe that there's no reason for him not to renounce his American citizenship, Your Honor.
How would the petitioner's divorce be classified under American law? Was it, example, no fault, administrative, or judicial?
I'm not very particular, Your Honor, with the manners how the divorce was obtained in the United States. But I know for someone that it's more of ministerial, Your Honor, wherein the petitioner would just have to get a copy of application, and then they has to fill it up, and then it have to be served to the respondent or to the other spouse. And that's what my knowledge about divorce in America or in the U.S., Your Honor.
Well, according to your pleadings, what was done is only to sign, or about that there's a checklist?
Yes, Your Honor. That's what I know that. And my knowledge on that, how they process divorce in the United States is quite limited.
So you don't know if that is a judicial or administrative
Yes,
proceeding?
Yes, Your Honor. But the only thing is, there's no, for as long, well, I'm more, with due respect, Your Honor, I'm more familiar with the United Kingdom, because in the United Kingdom, it's more of just like administrative, Your Honor. But in the States, I have no personal knowledge.
Why is no copy of the relevant California law attached to your petition below?
To be honest, Your Honor, the case was, because during the time, if I'm not mistaken, during the time that the petition was filed, the judicial affidavit law is not, it's very strict, Your Honor. And the petition was dismissed right away, even without being given due course, Your Honor. That's why the dismissal of the petition by the RTC, Himba Nueva Ecija, is motu proprio.
Yes, because you did not attach any authenticating documents, such as any certification of legal custody of the divorce decree records, or any substitute certification from the Philippine consulate in Los Angeles.
Yes, Your Honor, because it was already been authenticated, if I'm not mistaken, it has already been authenticated by the Philippine Embassy or the Philippine consulate in California.
Now, why does petitioner's certificate of naturalization dated February 20, 2019, right? Indicate his civil status as married when he already obtained divorce decree in 2010?
This is because, Your Honor, he's already married to another Filipina American in the United States.
So she remarried in the United States?
Yes, Your Honor. The petitioner is already married in the United States.
Then she obtained again another divorce decree to that second marriage?
No, Your Honor, because actually his basis in getting married is the divorce he obtained earlier. If I'm not mistaken, he got married to this Filipino American just less than 6 months after he obtained the foreign divorce.
And they're still
together.
Still together.
Yes, Your Honor. Actually, the primary reason why the petitioner is filed this particular case, even if technically there's no need, given the fact that he and his present spouse is already American, is purposely to have their marriage celebrated in the Philippines as well.
But he is married right now to a American citizen, right?
Yes, Your Honor. Yes, Your Honor. But as we know, Filipino tradition, they still also have their marriage celebrated in the Philippines. And they cannot do that because given the fact that the foreign divorce obtained by petitioner has not yet been recognized in the Philippines.
The second wife,
yes,
is she a Filipino-American?
Filipino-American, not dual citizen.
Okay. Filipino-American, not a Caucasian.
Not dual citizen.
What nationality did Petition declare in his immigration card upon arrival in the Philippines? Or what is civil status he declared on any official documents of late?
I'm not aware when was the last time he came back to the Philippines for a holiday. But to be honest, I don't have no knowledge on that, or I cannot comment on that for lack of knowledge, Your Honor.
Okay. Now, why is petitioner arguing on the basis of gender discrimination when it is not his wife that initiated divorce proceedings and secured the divorce decree? That was stated in that was your argument in your petition.
Again, I'm sorry, Your Honor.
You were arguing about the basis of gender discrimination, but it was not the wife that initiated the divorce proceedings and secured the divorce decree.
Actually, and well, although I adopted one of the argument of the, I think it is in my memorandum, Your Honor, in the comment, wherein I adopted the arguments propounded by Attorney Ligarda, wherein by way informa pro hac vice, that if this particular, if the particular petition will be granted on the basis of the petitioner, it should be given, or the fact, the position, rather, of the respondent should also be considered.
Okay.
And if
Yes.
that were the case, that will be an absurdity, wherein that particular the respondent will be still married to the petitioner, when the petitioner is no longer married to her.
Now, you argued that Republic versus Orbesido does not distinguish whether the divorce was obtained before or after the acquisition of foreign citizenship. How did you reach this conclusion?
Yes, Your Honor, because in Orbesido, the fact is, in Orbesido, Your Honor, actually it was based on the perspective wherein the Filipina, or the former Filipino, which is now the foreigner, has already attained, become a foreign national. And from the perspective of the Filipino, it doesn't matter when that particular, his former wife actually acquired the Filipino American citizenship, because that issue, that Orbesido was decided on the basis that it incapacitate him to remarry or regain his capacity to marry.
Now, you also argued earlier about, you mentioned about the application of the case of Manalo, and you stated that this is similar to this case. Are you sure of your facts? That the Filipino in Manalo acquired foreign citizenship after securing a divorce? Because earlier, the Solicitor General explained in her recitation the facts in Manalo, the case seems to be not applicable. That was a mixed marriage in Manalo.
Actually,
From
Your
the
Honor,
start.
yes, Your Honor. My point is, I understand that there's no identical, there's no the facts of Manalo in this particular case. But what I intended to argue, Your Honor, is the fact that in Manalo, actually Filipino can already initiate a divorce. And that is the point here, Your Honor, after he reacquired his Filipino citizenship by virtue of Republic Act 9225.
So the case here, the facts here is different from the facts of Manalo. Do you
Yes,
agree
Your
with me?
Honor. As I've said, Your Honor, this is a case of first impression. When there's no similar cases decided by the Supreme Court, that's why you have to adopt some arguments from the previous cases, which is in the case of Obresido and then the case of Manalo, Your Honor.
Okay. Have you come across the case of Tan versus Crisologo? About the retroactivity?
Yes, Your Honor. A retroactive application of 9225, Your Honor.
Yes, yes. What is your position on that matter?
I'm not very fully aware of the facts of that particular case, but I think the issue there was about the residency, Your Honor. Even if, correct me if I'm wrong, my understanding is that the retroactive application of 9225 does not include residency. Because the issue is that in that particular case, correct me if I'm wrong, is whether the residency period, which is actually required for her to run as congressman or member of the House of Representatives, is the one that would put at a highlight on that particular case.
Okay, thank you, Counsel. This, you have passed through my questions, but will not be the last. My colleagues will still ask you some questions, but at least you have composed yourself. May I now thank you?
Thank you.
May I now call on the Solicitor General? Awesome afternoon, Solicitor General. What is the official? I'm saying awesome because that is my hashtag for the bar next year. Awesome. Awesome bar 26.
And,
2026.
An awesome afternoon,
Awesome.
Mr.
Awesome.
Awesome.
What is the official position of the government regarding divorce in general as applicable to all Filipinos, considering that divorce is only available to Filipinos adhering to the Islamic faith?
The official position of the Republic of the Philippines on divorce is what is provided in the law, also to be interpreted against the framework of the Constitution. So the state recognizes relative divorce, not absolute divorce. Our law provides annulment, declaration of nullity, and as we have seen in the testimonies of the amici a while ago, as regards the legislative intent, that there is really a deliberate intent not to include a provision on absolute divorce. Now, juxtapose this to the constitutional provisions on the inviolability of marriage, and it isn't just, I believe that it isn't just an aspiration, but the Constitution says that the state shall protect it, referring to the inviolability of marriage.
By the way, Madam Solicitor General, is this your first time also to appear and argue before this court?
Most certainly, Your Honor. This is my first time.
Okay, congratulations also.
Thank you.
Now, constitutionally, are dual citizens a distinct class and valid classification when it comes to marriage or remarriage requirements in the Philippines?
We believe that it is not, because they are to be deemed as Filipino citizens, as well as they should be bound also by their other nationality.
Is it not constitutionally problematic for only one sect or religious group to have a statutory enactment relative to divorce?
Yes, it is wrong for just a particular sect to have, you mean the Sharia?
Yes, because as we have stated earlier, divorce is only allowed for the Muslim faith or the Filipinos adhering to the Islamic faith.
The Sharia law was passed based on the respect to the customs and the practices of the Muslims, and I think that, or I hope also that our Congress would be on the way to pass a legislation on divorce. As we have heard a while ago, it is only the Vatican and our country which do not have divorce. And if we follow legal realism as a philosophy, we should be acknowledging that the times have changed, and perhaps the time is now opportune to revisit the premises of the family code and the intent that is expressed by the Committee on Civil Code and the Family Code. However, it is our position that it is the responsibility of Congress.
So are you saying that because you are not adhering to the Islamic faith, let us say because you are a Christian, then you cannot avail of those benefits, if we'll say that is available to the Islamic faith?
Yes, that will be the effect, Your Honor.
How about those who does not have any religious preference? Let's say if I am an atheist, or I don't adhere to any religion for that matter. So why will that apply to me?
I believe, Your Honor, that what will apply is the law and the Constitution, which is actually not based on religion. The description of marriage is, I think, couched in secular language and not based on religion.
So what is the reason behind the prohibition for an absolute divorce here in our country?
Well, I believe that the legislature or the committee that drafted the Family Code and the Civil Code and President Aquino were of the view that relative divorce may be more acceptable than absolute divorce, and my distinction between the two is that for annulment and declaration of nullity, the cause is existent at the time of marriage, while for divorce, the reason or the ground is after the moment of marriage. So perhaps that is the rationale or the reason behind the preference against absolute divorce.
So it is because of public policy?
Yes, Your Honor.
Okay. Is Philippine public policy still harm when, for example, joint divorce decrees or agreements secured abroad with either the initiation or participation of both Philippine spouse are presented here for recognition?
Your Honor, I respectfully believe that the question on whether there is harm is not the only consideration when we consider something as public policy. Something could also be public policy if it defines the collective values or beliefs or customs of a society. And that means that if, for example, we allow the petitioner or we grant the petition of the petitioner, the fact that it could also offend the policy, the public policy as adopted by our laws and the Constitution is also an effect or is also defining what public policy is. So it is just not a question on whether does it harm, because I think the question will really not matter when we say or when we refer to the nationality law, because there could be a question why in fact the Philippines adopts a nationality principle. Why don't we adopt the principle, the domicile principle, which is being observed by the US and the UK or the common law countries, which we might view as the more practical one, the more flexible one. But I believe, Your Honor, that many laws have or they produce inconvenience, they produce impracticability. For example, when a couple wants to separate, Why can't it be that it's just an agreement? That could be more practical, could be easier. So my point, Your Honor, is just that maybe aside from the asking if it is harming the society, I think also the concept of public policy which is shared by the society, by the community, is also a very important consideration.
Thank you. Is there any explicit statutory provision stating that divorce is inimical to Philippine public policy or public morals? Or is there a basis for saying that our public morality at present abhors divorce?
I agree. In fact, when Dean Mel stated his position in his brief, we researched on whether there is prohibitory law, and indeed, so there is no prohibitory law. The Supreme Court pronouncements are consistent in avowing that absolute divorce is against public policy. The Constitution, if we look at it, and I was trying to also find if there are other constitutions which express the inviolability of marriage, and it is not many. So my point being that it must have been very important to the framers of our Constitution to put the inviolability of marriage in the Constitution and to fill up similar provisions in the Family Code. And may I also cite, Your Honor, a provision in the new Civil Code, Article 220, which provides that in case of doubt, all presumptions favor the solidarity of the family. Thus, every intendment of law or fact leans toward the validity of marriage, the indissolubility of the marriage bonds.
So there is no explicit statutory provision, it's just a public policy. Is that what you mean?
Yes, Your Honor. No express statutory prohibition, but that the laws do not provide a mechanism to avail of absolute divorce.
But policies can be changed with the changing of times.
Certainly, Your Honor. And it is also, as I mentioned, on the legal realism, because if society evolves,
yes.
There have been so many changes in the last decade, and the laws should also evolve. And that is why we believe that it is high time for the Congress to really open the debate and the discourse on this topic in order to adapt or to adopt laws that will reflect the changes.
It is the Congress, not by the court.
Yes, that is my humble submission, Your Honor.
Is dual citizenship for purposes of securing divorce abroad inherently inimical to the national interests?
It will be inimical to the public policy as avowed by the Constitution and as consistently pronounced by the court.
Thank you, Solicitor General.
Thank you, Your Honor.
You passed the test. Now, can I just ask one question to the amici? Okay.
Proceed.
Okay. Thank you, Chief. Okay. Now, it's so nice to hear different views coming from our distinguished and learned amici, Curie. Okay. May I just say that you are invited here as friends of the court. Hence, you may disagree with each other, or we might disagree with each other. Let us remain as friends. No, any of the amicus curiae may answer the questions, and if any one of you has a contrary opinion, you may express the same. Okay. I will just ask one question, then because we are only allowed up to 5 o'clock, so I will ask the other follow-up questions on the next session. Is there anything, again, an awesome afternoon to the amicus curiae? Is there anything deleterious to Philippine public policy or public morals when it comes to Filipino citizens securing divorce decrees in foreign jurisdiction and having the same recognized here? Attorney Ligarda, you were nodding your head. Can you answer the question, please?
Respectfully, Honor, an awesome afternoon to you and to your Honor. At wala pa ho yung bar syllabus nyo. So as a civil law person who reviews, nahihirapan po ako. Anyway, Your Honor, to answer your question. None, Your Honor. In fact, I know for a fact that when I travel around this area, and I have gone to Guam with some friends, and in fact with Justice Elo Santiago, I went to Guam with her a long time ago. We discovered, Your Honor, that Guam has a 7-day residence requirement only, and you can file a divorce. 7 days. So many Filipinos who are our OFWs were there doing that, Your Honor. And they come back to this country, having obtained the divorce in Guam, and the only requirement there is that the Filipino spouse here has to sign an agreement that they are not objecting to the separation of property and the custody and support of the children. So they signed this agreement because the Filipino spouse here wants the same thing, and that the divorce is issued by the court, I think, within 2 months. So there are many OFWs who are doing this, but of course they're not telling the courts this. But it's a reality, Your Honor. So if it is deleterious, it is because there is no divorce law. And I think perhaps it is time for the court to interpret Article 26, Paragraph 2 as including a mechanism in which to protect the Filipino here and abroad, Your Honor.
Thank you. Any contrary view? Yes, Attorney Pangalanan.
Not a contrary view, Your Honor, but I would like to say, Your Honor, that in private international law or conflict of laws, this is what we call a limping marriage. A limping marriage where the marriage is considered to have been dissolved under the laws of one state, in this case, the U.S., but still valid according to Philippine law. So I would say that what is more dangerous and deleterious is having a limping marriage, because we are uncertain, unsure about the rights of the parties, about the rights of the children. In the Philippines, under Philippine laws, the children will, of the second marriage, if there is a remarriage and children, by that second marriage, they will be considered illegitimate children. And until now, there is stigma on illegitimate children, although, again, the preferred term now, and I think more open-minded term, is for non-marital children, as Justice Leonen penned in Aquino v. Aquino, where I was also an amicus, if I may add. So I would say that what's more dangerous is to have this kind of situation, that we have children who are considered illegitimate with fewer rights. Again, successional rights are only 1/2. And the fact that they're a limping marriage would subject both families, the first and second, I think, into some legal confusion. Thank you very much.
Thank you, Pangalanan. Yes, Dean Santa Maria.
There is none, Your Honor.
There is no express provision saying that it is against public policy. And there is also no it's not against moral as you have decided in Lewis, where an unmarried woman living in with another person, having sexual intercourse is not disgraceful. In the same breath, Your Honor, a person trying to have a second chance in life, getting a divorce abroad, must be given an opportunity. Your Honor, the very fact that we have a petition for recognition of foreign judgment, the very fact that we have that in our rules of court, and as stated in Mijares, has become part of customary international law. We acknowledge the fact that we will allow Filipinos, if there are remedies abroad in a particular state, we will allow them. Gate lang tayo, yung petition for recognition of foreign judgment. We will see if it's against public policy. And second, Your Honor, public policy, as we have discussed, is evolving. This Supreme Court has decided a shift in certain public policy situations. In other cases, like for example, in the flag ceremony case, from Herona to it was a shift, complete shift. It was the Supreme Court who said that. And in agrarian reform, Your Honor, in Association of Small Landowners and in the Philippines versus Secretary of Agrarian Reform, from just compensation in cash, the Supreme Court changed the paradigm and said, no, pwede na yung iba, because the contextual milieu is so massive ang land reform sa Filipinas. No? And then, so that's what I'm saying, Your Honor. We need not have a law to define public policy. It is the distinct power of this court on the basis of that petition for recognition of foreign judgment to define that public policy as it is existing now. Because, Your Honor, as I've said a while ago, the danger, the destruction of an institution will depend on how we see or we apply a stagnant, obsolescent public policy since 1939. And the world have turned around so many times already, Your Honor. And since 1987, since that exchange between Father Bernas and Commissioner Gascon, saying that, no, it's not, we do not even discourage it. And then you have all this, as a matter of fact, it is this Supreme Court which is trailblazing the advancement of that modern attitude toward marriage, unlike the legislator. That's all, Your Honor. Thank you.
Thank you, Dean Santa Maria. Thank you, Chief.
Thank you, Justice Sam. For the record, this afternoon, petitioner and respondent presented their respective presentations. Thereafter, the amici curiae were heard also. Justice Gerland, you completed your interpellation?
I will continue my interpellation,
For lack
Chief.
of material time, Justice Samuel Gerland will continue his interpellation on October 21 at 2:30 p.m. Justice Kagi would like to raise a few points before we adjourn.
Can I ask counsel for petitioner? How do I pronounce your name? Mane?
Mane, Your Honor.
Okay. Counsel, I'm bothered by what you were saying earlier, that you didn't know some of the facts that Justice Sam was asking. And I noticed that your petition is very scarce in a lot of facts. So, let me ask point blank. Your client is based abroad?
Yes, Your Honor.
And you're based abroad as well?
No, Your Honor. I'm based in the Philippines, but I have a bit of practice abroad in the United Kingdom.
Are you a dual citizen?
No, Your Honor.
You're a Filipino?
I'm a Filipino. I opted to remain that so that I would not sacrifice my legal profession.
And your communication with your client is how? By telephone?
By telephone, but we're able to meet once for a brief in the Philippines, if I'm not mistaken. I just can't remember, Your Honor, because this case was filed sometime 2022, 2023, Your Honor.
Exactly. No, my concern is, we don't want to be spending a lot of time and we're here addressing a theoretical question.
Yes, Your Honor.
That's why I go back to the question of Justice Sam. Ano ba talaga ang hinihingi ng kliyente mo?
Just recognition, Your Honor.
Because he wants what? Because he's married already to
Yes,
to
Your
his
Honor.
girlfriend abroad, right?
Yes, Your Honor.
So therefore, what does he really want?
Because the wife demands, or the
Demands.
second wife demands, bear with my words, demands that they also be married in the Philippines.
And the wife is also a Filipino?
Filipino-American.
When you say Filipino-American, what do you mean?
Filipino-American, he's American citizen. I'm not aware if he already is not
There
a
you
dual
go.
citizen, Your Honor.
You don't seem to be aware of some of the facts. That's my concern. So, with the indulgence of the rest, maybe we can issue a resolution asking you to put down on paper, under oath, by your client, answers to some of the questions that we will propound, because these are a lot of these factual issues might have a bearing on this, like when did he apply for citizenship? Why did he put the word married in his application for, you know what I'm saying?
Yes, Your Honor.
So,
Can we require the petitioner to be present?
does he want to come here to be present so he can answer all our questions? Or he's afraid of being sued for bigamy?
I cannot commit if he can comes in the Philippines, Your Honor, because he's tied with his professional responsibility in the States.
Can he participate online?
I'm not so sure, Your Honor. But I'll try, Your Honor. I will inform you.
Is this guy a real guy? No, seriously.
Yes, Your Honor. I will be very candid in the Honorable Court. I was able to, it's most likely, it's the wife who actually pushes more for that they get married in the Philippines. And to be honest, it seems that I feel that for the petitioner.
You're referring to the second wife?
The second wife, Your Honor, for the second wife. Because the new wife in the States actually...
The new wife is the second wife?
Yes, Your Honor. The new wife, okay. The new spouse actually wants to have them also get married in the Philippines. And without recognition, the petitioner would run the risk of being sued for bigamy, considering that he also got married in the Philippines.
But he's also... okay. So she's naturalized.
Yes,
also.
The second wife, Your Honor.
Okay, so maybe a number of the questions will be addressed in finding out the personal circumstances of the second wife.
Yes, Your Honor.
When did they get married? When did she get naturalized? How exactly?
Yes, Your Honor. I will. I will undertake to
No, I want it under oath by them, not by you.
Yes, Your Honor. I'll try.
Is that you'll try?
Yes, I will talk to them, Your Honor.
You have to make an undertaking before the court that you will do it.
Yes, Your Honor.
There are so many, the court is not a factual finding court. This is not a trier of facts. So we expect that we have complete facts on record, but the facts are so
amorphous.
And, it's just so easy for you to say, I don't know the facts because I haven't talked to my client about this. But we are interested in the facts more than the law because we know the law, but we want to know the facts as well. First and foremost, we want to know the facts.
Yes, Your Honor.
Thank you.
Go ahead, Judge Marby.
Just to clarify, that the wife now and your client wants to get married in this country in front of their relatives is a very legitimate objective. And whether or not it will cost them or not cost them, whether or not it will affect their family life, etc., the mere symbolism of it, given our customs, given our traditions, given the concept of family, whether it is a second family, a third family, a traditional, non-traditional family, in my view, is a legitimate matter because I saw that it was being laughed at by our gallery and some other lawyers. I think it's a very legitimate concern, and I give a lot of respect for your petitioner, despite all the difficulties, to go all the way up to the Supreme Court in order to be able to do that. That's the importance of a family. Never mind if it's a second family. That's the concept of family in our Constitution. It is not only a first family. So I just want to emphasize that. But I join my other colleagues and ask you a bit more diligence in terms of gathering the information that you will think that each of us will ask of you. You've just gone through the first of the justices. You will go through 15 of the justices. Even Justice Monette has sent in her questions, and it is, as I see with the Chief Justice, it is 5 pages, single spaced. So if I were you, I would listen to what Justice Ben Kagiwa has said, and the statement of Justice Ami Javier, that you should communicate with your client. I am sorry that you are called out in open court, in open hearings of the Supreme Court of this country, but this is how important we see this case. I mean, you should appreciate that we called for oral arguments because this court thinks that these issues should now be discussed publicly. So I hope that you also do your part.
Yes, Your Honor, I will. Yeah.
Just to reiterate why we need facts. Before we came out for oral argument, we read everything, we were preparing. And there's a statement in your petition that respondent is married. So we were asking ourselves, married with whom?
Married to the petitioner, Your
Oh,
Honor.
that's not clear in your petition. So we were thinking that the respondent already remarried to another person. So those are the things that we want to be specifically addressed.
Yes, Your Honor.
Okay, thank you very much.
Thank you very much, Your Honor.
Okay, Attorney Maripe, I have dictated my order. We will resume October 21 at 2:30 p.m. Are there any other matters that we have to consider?
There are no other matters, Your Honor.
Okay, there being no other matters, this session is adjourned. Thank you very much. See you on October 21.
Please remain standing while the Chief Justice, the Senior Associate Justice,